Yesterday's no, please. Tender for
Video spectral comparator. This device is used for forensic examination.
where is the ground for disqualification?
As well as annexure
Page
page 153.
153. 53.
153. With the rejection mail, and the ground is at one page.
Yes, reason or rejection as recorded. Where is the reason?
Reason at page 155. The comment may I read that?
Yes. Any response to your representation?
No, still till today, the bid is yet to open. The technical financial bid is yet.
But this is you have made out a case of a discrimination that every other intending bidders have quoted the same material, same model.
The qualified bidders are from single OEM, that is Foster Freeman. In the market, there are three major OEMs. Those are not manufactured in India. All the bidders are representative of the particular OEMs, and the qualified bidders in the technical round, they are from the Foster Freeman.
They are from
Foster Freeman.
You are from
Regular. The manufacturer of the video compressor. And I just want to show the annexure 11, where the petitioner has participated in the tender process in the Nasik. There is an ISP Nasik, where both the products were qualified in the technical round. But this petitioner was disqualified here in the technical round because...
No, was there any difference in the specification?
No,
They must have indicated the specification in the contract.
The product should be performance based because the terms they have used, like I give an example that there are two laptop companies at HP and Dell. They put an specification of the Dell. So in that manner, Dell will be qualified. But the
no, it is within them. What specification they wanted, it is within their own domain. If they wanted a particular specification
they should have
of the equipment, so they must have indicated in the tender document itself.
Gone for the rule as per rule 166 of the GFR manuals. That is single tender inquiry. That they shouldn't have gone for the open tender manuals.
No.
But here the tender is for the open tender.
Specific.
Have you brought out the distinction? The persons who have qualified have the same configuration or same equipment requirement.
Yes.
As per the tender document that you have furnished. Have you brought out that distinctive feature?
Yes, I have.
They have rejected on the basis of your specification.
Yes, sir.
Of equipment.
Yes.
Right. So whether a similar specification which you have uploaded or punished, they have punished the same.
Yes.
Same.
But the company.
Where is that requirement? That it's a tender document they want to show.
In the tender document, my lords, under Financial 1 series, the specification they initially quoted, my lords, certain terminologies, my lords, like web build. It is a patented of the
Sir, there are many companies, they are manufacturing the different, the specifications gadgets. Now, if they have in their technical advice 46, I have seen that what they really wanted. If they wanted a particular, the instrument or equipment of a particular specification, you cannot say that other specifications that would also be included. Because it is their choice that what they want, considering the need and the requirements. So they have said that so far as the key technical and policy points are concerned, at page 46, they have said the high-end imaging system, what should be the specification? They said that so far as the intent UV illumination is concerned, adjustable band pass spot illumination is concerned. These are the things they wanted, and they say that your equipment does not meet those requirements which they want. At page 155.
that language they have used from a particular manufacturer.
That you can't say, manufacturer. That you can't. They want, no.
What requires a particular?
We are not a technical person. They are the best persons to see. We can't go into those nuances of the specifications. Neither you have an expert nor we.
This similar for
No, sir. No, sir. If they, because I've seen they have already indicated in the bid that what they really want.
Kindly say Annexure 11.
Buyer to use me. That's what I'm saying. It is a prerogative of the buyer that what specification they need. It depends upon the object and the purpose for which it is to be installed. So,
Kindly see for a moment Annexure 11. Page 253.
what?
Annexure 11. Page
Huh?
253.
What?
11, my lords. Page 253.
2?
Annexure 11. This is a comparison chart of two tenders, my lords.
No, that may be. That all depends upon the object, the purpose, the need.
Both the products are for the.
Sir, let us hypothetically consider one. The lathe machine they wanted. Lathe machine may have different specifications. Lathe machine is a homogeneous class, but they has a different specifications. If they want a particular specification, can you say the others have also sought for a lathe machine? So there you qualify. So you should also qualify here. No, because the specification is a most important factor.
Certain terms they have
No,
used,
sir,
my lords,
that cannot be
specified
done. No.
only with the
Others
cost
require-
of payment.
It is a bias requirement. They wanted that's the base of need.
That's what I am saying, my lords. They should have gone for the under Rule 166, my lords, single tender inquiry, my lords.
No.
The rule specifically says.
No, they have given an open tender, no doubt about it.
The
Everybody,
open tender, my
more
lords,
than one person has come forward. They will take care of that.
My lords, the open tender is, my lords, bias, my lords. They should have gone for the.
No bias. Why single tender they will go? Why?
My lord, the product.
Will it not encourage the nepotism and favoritism?
My lord,
What is the purpose of floating the tender?
The product is for one particular manufacturer.
Sorry, no, there are other manufacturers of the same specification. I do not know that there is any patent or a copyright or any design right under the Design Act. No.
They have floated the tender as per the patent, my lord. The
No.
amount they have used, that is
Sorry,
specifically
we
related to
can't.
the.
That is what if they wanted. No, they can.
Sky possible. My lords, the rule specifically says, my lords, if they want to go for a particular company, they can float a.
They are not saying there may be several companies manufacturing with the same specification.
No, my lord.
Where is the difficulty? No.
Specifically,
They have not used the brand, but sometimes they use that these brands are also there. That cannot be done.
My lords, here the clear violation of the rule.
No, sir. Show us the rule.
My lords.
What is that rule? What is this rule?
General financial rule, my lords. Yes, I have heard that.
What it says?
This is the extract of the rules members. The
Sir, it depends upon the conditions that it is only one company who is manufacturing this. Then in case of an emergency, that has to be done. But they do not find it. Oh no, this rule does not have application.
let's see all the qualified bidders are from the single manufacturer.
Maybe.
Maybe they will in the financial round. I may be qualified or not. That is a different aspect. Let me qualify in the technical round.
No. No, I don't think so. They have not used any brand. Single manufacturer. They have not used. Maybe multiple persons have.
They have used certain terms that is patented with the particular company that is those
Where you have made out a case. Sure. Where you have made out a case. In the pleading. Have you annexed the document that this is the patent certificate? This is only patented with this company, no other company will be allowed to manufacture. And there is a limitation of the patent, they are within the particular limitations. How can you argue at the bar? How can you argue at the bar without a pleading having made in this regard? Can you make out a case out of the box? You have not made out any case. There is no pleading. There is no document which is forthcoming, and you are arguing.
That pleading I have taken, Malus.
Where is that? Show us that you have said.
No.
Show us. We wanted that. Where is the case?
Paragraph 10, page 8, Malus.
Page
8.
It shows. Yes, show me. Where?
Which branding terminology to opposite parties issued by
No, which page 8 I am there.
Malus. Paragraph 10, Malus.
Paragraph.
Initially, they have used this, the second paragraph, Malus. But in certain terms, such as built-in trimming filter, replaced with advanced trimming long pass, short pass, and band filters. And the patented coaxial illumination with rephrased with precision coaxial illumination system.
So they have made it more wider.
Malus.
But you have not made out the case that it is only patented with a particular company and no other company will be permitted under the law to manufacture those particular equipments. You have not made out a case. You know, when there is a restrictions under the Patents Act. So you have not made out and you are arguing on the out of the box.
No, my lords, in this case,
You have simply said that initially when they floated the tender, these were the conditions which they have replaced before the last date of submission. Fair enough. That's the another thing. That's not a case of that it is patented with this company only. You have not made out the case. So this specification is open.
only for the call. My lords, the changes in the
This is you have not made out the case. No. What you are arguing is completely out of record.
the technical disqualification, my lords. They just simply
Sorry.
copy pasted
I think you have make good efforts in placing your case. The supremacy and the some kind of a freedom should be given to a tender floating authority as per the need and the requirements.
It is, my lord, the coincidentum is based on our representation, my lords, that they have mentioned.
Maybe so they have acceded to it. But you made a representation that this language should not be there. This should be a open
Yes,
language. They acceded to it. That means they do not restrict.
But
They
yes,
restrict the participation for one company. No.
Certain things which
No.
exactly relate to
You should have pointed out why you participated.
I was participating.
You participated with open eyes. That these are the terms and conditions. Once they took a decision and rejected that your equipment does not meet this specification, then you are taking all such plea that this is a single tender, this should not be done. Why you did not raise at the time?
I have raised my loss.
And they have acceded. You have raised this, they accepted your condition. And they changed that particular language.
Continuously, I have raised my loss. This
No, sir. Then why you participated? You could have challenged it at the stage of floating of the tender. You could have. You just waited.
No, my loss. I have raised several.
Did you challenge that these are the terms and conditions which will invite a single tender inquiry? They should not have done it. You could have challenged the tender at
Not
that
before
stage,
this court, my lords, but before the
without
authority.
participation. You did not.
Well, not before this court, but before the authority, my lords.
I'm sorry, I cannot. You'll have to. Then why you participated? You should not have.
I have participated because they would have considered that.
No, sir. You just took a chance that let me take. At the moment you found that you are unsuccessful, you are coming up.
No, my lords.
And raising this issue,
I am making
raising this issue which impinges upon the terms and conditions which is incorporated in the tender.
Repeatedly,
At the stage of after the stage of participation.
repeatedly, I am making representation. That's why, my lords, the tender was closed in the month of March.
After you should not have participated, raising the issue, coming to the court before the tender is opened. You could have come that my grievances are not being addressed by them. You should have. That it is a case of favoring a particular class of the persons.
My lords.
You did not. With open eyes, you participated.
Well, that we have taken, my lords. That I have participated in a protest, my lords.
You are aware of several judgments of the Supreme Court of Justice. After participation, can you come and say that all these things are wrong? Sorry. The minister
my lord. I'm on virtual mode, my lord.
Yes.
My lord, here I'm the L1, my lord.
Where is the annexure?
8, my lord.
Where is
Yes,
the-
my lord. That is my lord, that's page 56, my lord.
56 is annexure 9.
I'm sorry. I'm sorry. That is my lord. My lord, that is at page 53, my lord. I'm sorry. It's 53, my lord. Although I satisfied all the conditions.
Yes,
I've
yes.
given- Yes, ma'am.
Then the annexure 10.
My lord, 10 is the one. After rejecting that, my lord, they have started a fresh tender petition.
Yes. So fresh
Yeah, you
statement
will-
have floated.
Yes, ma'am. And
Yeah.
although I have quoted, my lord, 32.70 less than the project cost, my lord.
Sir, what they have elaborately discussed that this is for flood protection work on a right flood bank of river
Yes. Yes.
Vasundhara.
Yes, ma'am.
Yes, such and such. Then they
Yes.
said that you should give a complete comprehensive breakup of the material,
I have
labor,
given that, ma'am.
machinery,
I have given
components, unit.
I have
You
given that,
submitted
ma'am.
earlier that on the basis thereof they wanted that is not sufficient enough. You have to give a further the comprehensive one. You submitted
they
the
are-
same, and then the
they are-
authorities have worked out on the basis of your breakup and say that this is absolutely against the approved estimated cost.
Well, the
They,
estimated
they,
cost,
they have cancelled it.
but they are cancelled it on the ground that it may not be possible to complete the work within the
Because the labor minimum wages rate guidelines, nothing have been followed by you.
No, not at all, madam. They have misinterpreted, misunderstood that with due respect. Minimum wages act, my lord, what my humble submission is, my lord. I have got, my lord, a stone quarry unit. I have also got my the stone crusher unit. I have got the machinery, my lord, for the blasting purpose, for preparation of boulders, preparation of stones, chips, my lord. There I say that if for that purpose labor it 10% labor work is required, my machinery complete, my lord, the work of 7 persons. So it will be a reduction in the number of the engagement of the laborer. So in the pro rata basis, my lord, I have said that I'm charging less toward the laborer. I am not giving any reduced amount of minimum wages act to the employees, laborers they are appointed, engaged by me. They misunderstood that. They also asked me about give a copy of the lease agreement that you have entered into with the government of Orissa regarding the stone quarry. That also I provided. I have the resources. I've got the machineries, dumper, everything is there with me. Despite that, I am giving at a price manner which is much reasonable manner. I am saving the revenue of the government. I've got 20 years of experience in that field. In that area also I have conducted the work under the same department also. Now it's a competitive world, my lord. People are giving, my lord, putting price below the project cost. I've given that price. And if I have given the undertaking also that I'll complete within the specification, within the time stipulated. And if your lordship appreciates, it's my profession. If I commit any mistake, my lord, I am liable for action, even also blacklisting. I am a graduate engineer. I will not do anything wrong to affect myself also. I have given all the, and in that annexure 8 also, your lordship also appreciates, they have quoted also. The price that I have given is much less. It saves the government's revenue also. And now they are saying that we'll go for higher bid. For what? It is only to, my lord, drain the revenue of the government. I don't have any, my lord, any my lord, adverse remark to my career for such a long period. That is why last time, my lord, the instruction was sought for also. I have got all men, machinery, everything. I'll comply with the
They
mandate
have
of law.
given, they have given several, the points. It is not that on the simply a level. They have also said that, so far as the rate quoted by the agency is the material said, that is a zinc coated PVC hexagonal mesh wire gabion boxes. You have approved the statement is 2310 per cubic meter. You have quoted 800 per cubic meter.
Yes, I have
This
given less.
is very less, and the agency has not submitted any documents in support justifying how he can procure at such a lower price.
I have also repented at them. I have also sought them. If you give an opportunity of hearing directly, also I can explain. That this rate I am quoting, which you say that it is less, it may not be possible to complete the work within the stipulated period, within the stipulated standard. I will satisfy that. I save the
You
government
don't
revenue.
know that you have purchased that particular the excavator way back in 2010,
Yes,
but not
madam.
submitted
Yes,
any
madam. I know.
fitness concern, fitness
Yes,
certificate not submitted.
Those are owned by me. Those are the machinery required for the construction work. Excavator I have got the dumper, I have got the
What do you say
tipper.
about it? Why?
No, this order itself states that they is not complying with
No,
requirement.
he is not complying. He is complying. He has stated that I will do it.
After receiving the complaint, now again opportunity was given to him to resubmit if he wants to submit anything. He has repeated the same thing.
No, that we do not know. If I go item wise,
Yes,
UQ item number 1,
yes,
only thing is he has shown that I have got the Hitachi excavator.
yes,
That may be a 2010
yes.
make. You simply say that you have not submitted the fitness certificate.
Okay.
Now they have to do it.
That is
They
not
will
required.
use it.
They have
They
to
will use it. That it is
That is not
good for
required.
that or not. They have to execute the work to your satisfaction.
unless fitness certificate is there, work will be stopped.
What?
Then will be a
They have
difficulty.
to- they have not.
There is a reverse ban.
My lord, I
I
have submitted,
understand.
my lord, I have submitted that. So far that my lord, that Hitachi, my lord, that excavator is concerned, my lord, that is a, my lord, chain mounted machine. It is not registered under
It
the
is
Motor
less
Vehicle
than
Act. That is not
32.70%, less than
Then you are saying
10%.
transportation cost for the loser by tipper.
Hmm.
1 kilometer, the rate quoted by the agency is 24.66 per cubic meter against the approved estimated rate of 43.88.
Yes, I have given less quote because I have got the tipper.
Everything is much less than the estimated cost. No, sir.
I
You
do the work.
should compliment him. Sir, you should compliment him that he has quoted less the estimated cost.
Ultimately, if the work will not be done, taking action against him will not
Sir, are
apply
you
to
not
work.
taking a EMD? Are you not taking a security deposit? Are you not taking a
That will not
guarantee
suffice to
for
work.
this
The
execution?
question is that we know full well he cannot do it. Instead of saying that yes, I can do it in a less cost. Less means less than
Have you
30%.
got any past antecedents that he has not completed any work?
Yes.
Have you got a single past
That is not there.
antecedent?
But
If he has not violated or delayed any execution,
Yes,
how can you perceive that he will not be able to do it?
it's only speculation, unfounded apprehension only.
it is to be speculative when it is
Maybe some
much
other
less
reason
than
behind
it is less than 15%, 20%. Up to that we can consider. It is 32.70% less than the estimated cost. It is practically not possible to do it, and he is not able to explain to the satisfaction of the authority. If authorities are satisfied with this, then is the opponent
What is the subjective satisfaction? Means simply because the rate is quoted less, the That means there is an apprehension.
He has to explain why he has.
Can he quote above the estimated cost? I'm asking. Can anybody quote above the estimated cost?
My lord, may I submit one thing, my lord? Earlier, my lord, the negative capping was, that negative capping was 14.99.
No,
One
I
cannot
understand.
quote,
No,
but that is abolished.
Your
One
Lordship,
can
can you
quote
see
any amount.
the government notification itself, the government notification dated 3/1/2026.
Yes.
I've given a copy of this.
Yes, what is this?
Sure. Viticulture, when it is not satisfied to the authority that they can do it, they can go for the retender.
What?
Paragraph 6, last one.
I think they have included it.
They have quoted it.
They have included it here, I believe.
Yes, unanswered last paragraph they have quoted.
I have quoted that.
Justification for abnormally low bids shall be scrutinized
Included as an annexure.
technical
I've seen
committee.
that.
I have given with a memo, my lord.
Last,
That
last.
is-
Yeah.
I was looking
You
at
got
it.
to read the beginning paragraph, first paragraph
Clause 6,
itself.
clause 6.
Before that, you got to first paragraph.
Just a minute. I'll
That they have abolished, my lord, the earlier, my lord, the ceiling that one cannot bid below 14.99, that is abolished. Now one can quote any amount, my lord, below the estimated cost.
It's already quoted.
Clause 6.
It's already there.
Yes, there but is not legible, that's all.
I stated in my
Legible,
description
legible.
also. I stated in my description also.
The justification for abnormally low bids shall be scrutinized by the Departmental Technical Committee and
No committee has
the
been referred here.
authority of the administrative department for the approval of the additional performance security. An abnormally low bid is one in which the bid price, in combination with other elements of the bid, appears so low that it raises material concern as to the capability of the bidder to perform the contract at the offered price. Procuring entity may, in such cases, seek written clarification from the bidder, including detailed price analysis of its
Yes.
bid price in relation to scope, schedule, resource mobilization, allocation of risk and responsibilities, and any other requirement of the bid document. If after evaluating the price analysis, the procuring entity determines that the bidder has substantially failed to demonstrate its capacity to deliver the contract at the offered price, the procuring entity may reject the bid proposal. However, it would not be advisable to fix a normative percentage below the estimated cost, which would be automatically be considered as an abnormally low bid. These amendments are taken from council.
Here, my lord,
So,
they asked me, I gave the clarification, I gave the price analysis also. I submitted about the man, machine, resources, everything I have given. In Annexure 8 also, the order also reflects that what all I have given. They have not referred it to the tender technical committee also. There should be a reference to the tender technical committee. The order doesn't reflect about that also. The authority who has refused to accept my L1 bid should have referred it to the tender technical committee, a committee constituted by some experts to analyze about the price bid and the resources that I have to complete the work within the time, within the stipulation or not. That he has not done. And he has no more to ask from me the explanation. I have given that. I have given the details about everything, including the price analysis. Point-wise, I have given. Despite that, now it is rejected, saying that this may not be possible to complete the work within the stipulated time and stipulated amount. The reason is, my lord, something else, my lord, I may not be able to speak it in the court. I am to save the government money also. Revenue is also saved here. And I am conscious of the fact that I am a contractor having more than 20 years of practice in this field. If anything goes wrong, I lose my own livelihood. I'm not playing with anybody. It's not a small thing that I should do something lightly.
It's abnormally low. Abnormally low.
Just to ignore my claim, my lord, I submitted, my lord, the order of the, my lord, the State Pollution Control Board regarding, my lord, the order to, my lord, operate, my lord. They say that where is the lease order? Lease order is, my lord, given prior to, my lord, grant of permission to, my lord, operate the stone quarry. Consent to operate is granted only after the agreement with the government. I gave a copy of the consent letter of the government also that I have a stone quarry. I have got the sufficient resources. Then they asked me to give a copy of the lease order, lease agreement copy. That also I have given. Here also I have given as an exercise. So many materials, everything is there. Resources are there with me.
That is, this clause 6 talks about two things.
Yeah.
Once you find that it is abnormally low, if it is abnormally low,
Yes.
you have used the word, you can ask for an additional performance guarantee to be given. Why not you ask for an additional performance guarantee?
I am prepared to do that also.
You will give, at least securing your position if he fails to meet.
That is true, Vilas.
So, and where is the decision of the departmental technical committee? Where is that?
That part I was taking instruction with
What the technical, the departmental technical committee has not done?
must have been done.
Where is that? And this is what is the principal secretary to the, sorry, this is the rejection is at the based of additional chief engineer. Who floated the tender? Who floated the tender?
Page 62, clause 20, you are referring to. Without assigning any reason. Cancel.
That is about the free standard, madam.
Of course, when I am
Yes.
taking cue from that, so they
Yes,
can,
madam.
they need not. You pleaded that they have not assigned any reason, or the order is not reflecting whether they have referred it to the technical committee or not.
Yes, sir. Yes.
So that they need not give you with this clause.
Where is that? We do not find anything.
That part I have taken instruction with
And secondly, you can't. This cannot be a consideration in this regard. You can ask for an additional performance guarantee.
That is true, Vilas. That also I was also thinking about that, Vilas.
So,
Let me grant you some time. Let me take instruction with regard to that. If
no,
agree
then
to-
you are going to open it by 29th of June.
Yes, ma'am. This month itself.
Yes.
So, that's the last date of submission.
Let me keep it to 1 day time also. Let me give 1 or 2 days time. I will give it
Come tomorrow.
tomorrow.
Yes, you take the instruction immediately today, sir. Tomorrow.
No, on the last
Tomorrow at 2
occasion,
p.m.
Tomorrow too.
on the last occasion, in the vacation,
The
Number 3.
এটা শুধু পাচ্ছি ফাইল আছে
I'm giving an order taking.
Yesterday, my lord, listed my lord, it is seeking two months' time. But in affidavit there, that's our ground is that already we have considered and extended 1 year. And he is living for 4 years, 10 months in the one headquarters, so we did not include that. In this regard, they are paying for 2 months' time. But
3 months because
why you said 2 months, now 3 months?
but only
No, sir, the affidavit is not appropriate. You will not accept. Affidavit must be very clear. You have simply said the true copy of your application which you have made to the authority. That's all. There should be an affidavit that I wanted.
affidavit I have given my lord.
No, sir, you have not given.
Last
No, paragraph 5.
last page my lord.
No, paragraph 5, I see. 3 months, sorry.
I'll make it.
Client, no, sir, definitely. Then it is contrary to the affidavit. So you have already relieved?
Already released. Already released.
In annex, I have annexed that document, my lord, on the food affidavit.
Yes, yes. Even relieved.
Yes, the director has directed not to release him. That document has.
No,
been
no,
in the
that is not there.
Okay.
No, you have already been relieved.
Your affidavit on
Your own affidavit
16/6.
shows that you have been relieved.
16/6.
We have taken.
Para 4.
Yes, ma'am. But now the direct, after the court's order, my lord, on 18/6, my lord, LR 6 is the director's direction, my lord, to the DI.
Because an order was passed in the vacation court.
After vacations court
Oh,
order.
he has filed an affidavit
They have released, no?
saying that in the meantime, the petitioner has been relieved from Bhubaneswar with advice to join in so and so. So that is his affidavit. That is what I am bringing it.
Yes, yes.
It is on record already.
What is the date of the operation?
Not because of stabilization.
Say, sir, that is continuing for a long time. That cannot. And this is such a disease which should not wait for long. Then what is the correctional measures which they have taken?
Only.
If this is 2 weeks, then it will take a longer time. Let you go join, apply for a leave, they will definitely consider for a leave.
Whenever is required, we can relieve him for the.
How many siblings you have?
We have only one son, man. And one daughter, one son. Daughter is married, and only son.
So what the daughter's role? What is the daughter's role? Where is she?
Married and she's.
Say what? That does not detach from the family. I think emotional,
Yes,
every bond, the bondingness is still there.
staying with one.
So what? That means detached from the family. Nowadays, I do not believe that. They take more care of their parents.
I think you are arguing in service matter. Rehabilitation assistance. He was the cousin arguing more in that.
They take more care of the
Yes, yes,
nowadays.
definitely, definitely.
No, you join and apply for it.
Once the date is fixed, then I think he will not be that rude to.
Undergone, my lord. It had operation. Because blood is less, my lord. It's not stabilizing.
So blood is never less. It may be a hemoglobin or other
Yes,
elements or
That
may be
normal.
less. Blood would remain, otherwise.
Yes.
Go join, apply for a leave. Go join, apply for a leave, they will give.
If on Manipur, they are not.
Sir, they will give you a leave, sir. Yes, yes. The single bench has discussed the petition.
Because he has taken more than.
12 requisitions in one order, my lord.
Case is in acknowledgement.
Yes, no,
And dispose of.
I did, yes.
Full.
Weekly list, fresh admission item number 1.
What is this school? What is the status of this school?
It is a government school, my lord. Government secondary school.
under the control of the education department?
Yes.
Direct. What is this? Why this mandapam is constructed on the school land?
No,
Who is constructing the mandapam on the school land?
opposite Patmos 7.
Who is the
Government is constructing through opposite Patmos 7.
No, but that is he's a contractor or a whatever. We are not concerned. It is the government who is doing it. How?
Let's see, at paragraph 4.4 figure, they have made a cause of action that this Kalyan Mandap is being constructed within the premises of the school.
Correct. They have also given a ROR
That
which shows that this is. Their case is that it has been sanctioned in another plot, but the construction is being done in this plot.
No, I have received instruction in this matter.
Yes.
Actually, what happened, the plot numbers they have mentioned, that is 1628, 1629 and 1630, all these plots, the total area was one acre. That was allocated to the school. Thereafter, it was not suitable for the school's playground. It was not suitable for the school playground. That's why they need more land. And 3 acres of land was allotted to the school. Now the school is functioning over the another land since last 40 years. Over these 3 plots, the school is not situated. Thereafter, the government decided to construct a Kalyan Mandap on these 3 plots.
How? Sir, have you shifted the school from the existing plot to another plot?
On these 3 plots, the school was never constructed.
Oh, but it was allotted to the school, maybe for playground or whatever. Once the record of right indicates that it is allotted to the school, can you do it without altering or rectifying the record of right?
They have taken step.
What taken? Then how you have started the construction without taking changing the record of right or altering the record of right?
It is already done.
Where is that? Order show us that the ROR has been rectified.
Then I will file an affidavit.
What I won't file an evidence. Show us. He has shown a prima facie case that this record of right shows that this particular plot belongs to the school. How can you make a construction of a mandapam on the school plot? Though right to education, Article 21A is taken by them, but whatever.
Can you see page 2?
What?
Recently, the district education officer Devgarh has applied for the alienation of the land in favor of the company, in favor of construction of schools. Right, letter number 1. So, in the meantime, the Tahsildar has alienated the land in favor of the education department in high-tech Khata number 449 of /1. So, there is no need of earlier land, that is high-tech plot number 1 that they are alleging here. Those are also for construction of the school building.
But the school is not going to be constructed for the first time. It is already in existence.
Yes, ma'am.
Already in existence. You wanted to shift the school to another plot.
No, military. School is not constructed over that land.
This makes it
there. It is already there.
This makes it clear. This one. Yes, but.
Huh?
And we have given 3 acres of land to the school.
No. This is what there is no question of any. The school.
Not in the school.
That plot number and all.
Where is our
the details are not
ROR?
given.
Where is ROR? He may be relying on an old ROR. There is a correct rectified ROR.
Let we will find.
Sorry, sir. If this is the correct state of affairs, then you do not.
The motion to carry is annexed to the report
Sir,
of the
this may be an old because he has said that there was an alienation case of number 10 of 2025.
Yes.
And this is much prior there too.
If it is so, my lord, I have no case.
No case at all.
That is all. School is now here and the
The high-tech survey number, these are the different plots.
different price.
What to do on that basis, dispose of the matter. Disposing of the matter on that basis.
Yeah.
The instant writ petition is at the behest of Several defects are very, we appreciate one of the public interest litigation conducted by you, but is it maintainable? Does it not concerning a particular bias or a particular personal interest? No, sir, you wanted the investigation to be done. This cannot be. That shows something else. There are a provision under the Criminal Procedure Code. BNSS now has come.
Yes.
You can approach, but not in this kind of a public. And there are several defects which you have not removed. Question of defects in the affidavit format, verification procedure, non-compliance of the mandatory service to the statutory authorities, they have not done. Not we like to pursue or
I only clear also.
no, this is the vested interest. These cases, they require, those cases, the police case number, investigation is going on, obviously. These have been filed in a recent origin. So 120 days, 180 days, or a 90 days, or a 60 days period is provided. How can the court interfere?
I
Admitted ones are, we are stuck up with our judgment.
My lord, I am.
Have you admitted? Why you are not paying?
My lord, no, my lord. Interesting point is that, my lord. Not this, that admission, my lord. Admission, definitely, my lord. What has happened, my lord? What happens? They tender and they get a person called Neve LLP from Delhi. My lord, who takes the contract of 100.
Oh, yes, there's a third party liability.
Yes, my lord.
Why? How? Yes, how can you maintain a sorry, I read it now. I remember.
Yes, yes. My lord,
Oh.
I at the
If they have not paid to Neve, you are a subcontractor under the
yes,
Neve.
yes. My lord,
If they do not pay, how can you?
no, I bow down to all that, my lord. In fact, I was first indicating that I have very difficult case as far as High Court is concerned. I am only indicating, I'm only praying for a limited purpose. My lord, may kindly pay. I must bow down that I don't have a writ, I cannot move the report. My lord, I am only indicating one thing, my lord. What happens? They come from Delhi. What they do, my lord, they take 184 page, 180. What they do, my lord, they get these MSMEs to do the entire job from Orissa. And having done that, my lord, they don't pay.
Under the MSME Act, you know the arbitration is there. Everything you can do it under that act.
I quite agree, my lord. I am also myself not convinced, my lord. I am only indicating, my lord, at this juncture.
Neve is not paid.
Yes,
Whether the Neve has received the payment from them or not, it's not by our concern.
yes, they have received the money and I have not paid them. I am only indicating, I am not asking, my lord, for my lord, to pay.
No, principal contractor to subcontractor.
I have no case. I cannot make up my lord's jurisdiction. May I pray, my lord, one thing, my lord, subject to pleasure of my lord. Let the government decide this and let after we will.
Third party,
No, my
who's
lord.
not a party to a contract.
No, my third, they have indicated they can enter into third party contract. The contract itself says, the LLP itself says that, my lord. My lord, the LLP, let them, my lord, I'm not even asking that. Let them just consider, I make a representation, let them consider that. I'm only saying that much. My lord, may kindly see page 184. What they do, they take that LLP from Delhi, he gives it turnkey to these people and doesn't take the money and goes away.
So what? So the government is responsible for any.
No, my lord. Government also, my lord, the agreements also say that they can
Correct. So it is really a private dispute between a contractor and a subcontractor.
I bow
So
down.
if it is a private dispute, then how Article 12 authority
no, I
have to satisfy that they are not.
I cannot justify, my lord. I'm only stating one thing, my lord. Let me make a representation to the authorities. Let them see if they can
simple
find out
recognition of your right. I have a very bitter experience. I say, tell you very frankly. This kind of a representation theory is, I say, artificially creating a cause of action for another litigations to come before them.
that.
If we do not find any right emanating therefrom, then why should I direct the government to consider
No,
that?
I'm only saying, my lord, they have 120 places, my lord.
They have paid the money to their contractor. Now if the
They're paying,
contractor
it's
has
continuing.
whatever, if the contractor is not paying, it's a private dispute between
I
yourself.
quite agree.
It's a private contract. That is what
I-
you have a reference somewhere else. If you are an MSME, you know under the MSME Act, you can do. If you go before the regular court, you know that what are your rights before the regular court. You can.
Right, or not everything. I have indicated in the first instance that I have no case, my lord. It's very difficult for me to, my lord, make this. Well, they came this morning to me, my lord. I am not convinced myself. I convinced my lord.
Who is that on record?
My learned friend.
You drafted. Why you did not go into all those aspects? You ought to have clear your consent. The senior has already indicated to you.
I, in fact, told him that you better ring them up and tell them to go to MSME. Because MSME will get more money than what you will get here. My lord will permit us to withdraw and file appropriate act on this. And my lord, there is another matter.
Appropriate for.
Yes. Yes. My lord, there is another matter also.
File a withdrawal.
I'll give that other matter, my lord. A memo for withdrawal. Yes. My lord, there is another matter pending. Let's actually dispose of it on the same.
Which one?
WPC 5726 of 2016.
List it as a supplementary list. Otherwise, it will not. That matter is not listed.
No, my lord.
Give it, list it today and then dispose of this. File a memo there also.
I may be permitted not to be waiting for the
No.
matter, my lord.
Yes. Item number.
Item number 4.
Yeah. One.
Lordship, kindly see the.
Just 1 minute.
Sorry, excuse me, Lordship.
Where is annexure 8 and 10?
Lordship, page 77 is annexed 8, Lordship. And 10 is page 93, Lordship.
Where is that clause 6.27.2?
Lordship. It is Lordship.
Page 47.
Present cause of action is something different, Lordship.
Yes.
Yesterday, Lordship, they have blacklisted me without any notice, anything, Lordship. But when the matter is
Where is the order of blacklisting?
Lordship, I have brought by of Lordship, I have interim application, Lordship.
Interim application without challenging the order of blacklisting.
Amendment, everything I have got, Lordship.
Where is the amendment?
We have not received the copy.
When you are giving copy, you are refusing. Now you are saying.
Lordship,
One,
allegation.
I was offering him copy. He refused, no. At the time of call, he will supply. Now he is making allegation, no, not.
You're asking me.
No,
Yes,
sir.
I was referring you to deny.
Mr. Tripathi, that is not very healthy. If your counterpart, I think the brother who is offering you a copy, maybe at any point of time, when you refuse,
No, brother.
you may say that you have received just now.
Yes.
That's a different, but you can't refuse. He's making and accusing you of a serious allegation
Milad,
that you have refused.
well, sometimes he accuses many things, Milad. His associate told me it is served to our office, but it is not served to our office. It is not in my.
No, he may have approached
Such
you.
of application should not be done, brother. And my learning senior goes.
Hey,
Your junior has not,
Will not.
your junior has not,
Yes, judge. You have not heard.
Mr. Jared, don't join the issue.
I witnessed that lordship. I have seen he was offering, but he denied. Don't tell lie, Mr. Judge.
which is an application for amendment.
I mean, 118. 118. 11683 lordship. 11683.
When the petition was filed,
Mr. Richardson filed lordship.
yes, 30th of March.
30th March lordship.
So it's a subsequent event. So it's a natural amendment has to be done. You received the copy now.
Just times.
You are allowing this amendment. Whether is a subsequent event.
Yes.
Department.
He has to file amended petition.
Petition was filed.
Item number 5.
Item 10 to make it easier. This is the
Yes, just 1 minute. Malas, give us 30 seconds. Where is annexure 4?
annexure 4 Malas at page 31.
Which serial number?
14.
Is any other clarification given by them?
No, my lords. That is the whole dispute which I am raising, my lords.
What is this, the minimum eligibility criteria is not met by him?
That's here, Malas, I would request for 1 week.
Instruction next week.
May I pray in the interim there should be no further proceedings on this.
Proceedings are already, L1 is already declared, the work is already closed. It's as per my own instructions, my lord, because the officer is known.
Coming the next week.
Item 6.
Is a case of a discrimination. In some other bidders, they have also not given, put the digital signature in all the pages, all the documents. You have qualified him and you have disqualified him. Is the case?
Yes, not participated in submit.
Your Lordship, I'll file an amendment that yesterday.
What amendment? You have not participated, then how can you challenge this?
I have asked him for clarification, Your Lordship.
What clarification is required? How can you do it?
Your Lordship, that's why I am
No, nothing.
Then to amend actually, Your Lordship, that you kindly allow.
No.
Subsequent development taking places in.
What are you talking about uniformly? You have not participated there. How do you know that they have not? You wanted to collect an evidence through this, the writ petition.
No, Your Lordship.
So this is what an attempt is made. That they are not uniformly enforcing this. That means there are certain bidders who have not put all the documents with digital signature. You wanted to collect the evidence. Who have done, who have not done.
The previous bits, Your Lordship.
Sorry, we can't.
Kindly allow me to at least amend them. Kindly allow me to at least amend the petition.
What amendment? What amendment? Tell me what amendment?
Facts and issue.
What?
There are certain facts and you can interpret.
Which are the nothing? If the facts have not been treated, then it is a defective one.
Then, Your Lordship, kindly permit me to withdraw and I will file a better question.
Next.
Item number 7.
Yes. Hey.
My lord, orally I have been instructed that it has been already been paid, my lord.
Next.
Item number 8.
On the matter of Mr. Dunoli appears and others matters are not appearing.
As a long vacation, Lordship, that's why test matters, some matters, many matters is yet to be listed. Some 3 to 4 matters as well. So,
Why you're chasing somebody who is really quoted the lower price?
that's it.
If they are unable to the supply, they will take action against them.
No, Lordship, he refused to accept the bid, Lordship.
No.
He refused, Lordship. Lordship, kindly come to Lordship, the present application.
What are you talking?
Lordship, kindly come to.
Party number 13 has been declared the lowest bidder.
Lordship, kindly come to Annexure 9. Page 9, Annexure 9.
As per the last order, petitioner had undertaken to file an amendment to the writ petition, my lords.
What amendment?
Because subsequently this tender was cancelled, my lords.
Okay.
That has not been, as per the last order, my lords, 12/6/2026.
Where is that? Show us.
The amendment application is not been.
Where is your, how you say that it has been cancelled? Do you have the order of cancellation?
Last time they had filed an IA, my lord, in that they have annexed that amendment.
In Annex 9, which
That is the recommendation, my lord. Thereafter
writ petition 1142 of 2026. Is it at this BS? Yes, the same petitioner. So that was
It's item number.
reference, yes. 93, page 93, in Annex 9,
Yes, my lord.
under reference,
Yes, my lord.
WPC number 1142.
Yes, ma'am. That is the tag matter, writ petition number A360.
Here it is tagged.
Yes, ma'am.
Yes, sir.
And that is adjourned to 1/7/2026, madam. In that matter, notices were issued on the last occasion.
No, it is not tagged there.
It's item number 8, two matters were shown in the list.
Triple one is.
So there was a proposal for cancellation. Now it has affected.
Yes, Lordship. They have come up, Lordship. Kindly see the.
Where, why? Yeah,
Next-
then-
next-
then if it is already cancelled, cancelled.
No, Lordship. There's a law says, Lordship. Lordship, once they have opened my financial bid, I am the L2, Lordship. When the condition says, Lordship, this award should be given to me, Lordship, without, Lordship, kindly see the annexation 9. So, if Lordship already fast bid, Lordship, kindly see annexation 9. The Lordship rightly pointed out, I am chasing before somebody. Lordship, this is very clear in this annexation 9. Lordship, may I read, Lordship? It has come to the notice of the understanding that tender call notice was published on supply of different items. Kasturba Gandhi Balika Vidyalaya, such and such, Lordship. Tender call notice was invited the tender under chairmanship of BDO, Lanjikar and other officials, Lordship. And last two lines, Lordship. That is Sergeant Tender subject to production of the sample items of verification of
Has
quality.
he, that he has failed to produce it.
Lordship, because that is
So
that is not
they
never.
decided to cancel.
No, Lordship, they have never decided to cancel, Lordship. It's a recommendation,
He wanted that it should be awarded to him being an L2.
Lordship. This is a recommendation for cancellation. That was under challenge.
That is what now says that the cancellation has taken.
Lordship, kindly come to second bid application. That is, Lordship.
Eight 362.
Second bid application, Lordship, kindly come to page, Lordship.
Cancellation order page.
No cancellation order, Lordship. Only the state they have come up with tender call notice.
Obviously, impliedly cancelling the earlier tender.
Can I refer to the last order in writ petition number 17024? In last order dated 12/6/2026, in writ petition number 17024, therein in para number 2, the petitioner undertakes to file an application for amendment challenging the tender call notice of 5/6/2026, which has been annexed as Annexure 10 to IA number 1092929 of 2020.
Yes, you have
That-
not.
Yes, madam.
You have not taken out an application for amendment. This liberty was given.
Yes.
You undertake, sir, Mr. Donoy. Why you will not file an application?
No, second press writ application,
No,
Lordship.
no,
Second writ application, Lordship.
no.
Second writ petition. Lordship, kindly
What is the number?
Lordship, that is connected, Lordship. That is.
I am asking you, sir, what is the number of the second writ petition?
Madam, it's 8362 of
Correct.
2026.
This is reflected in this particular order.
Yes, madam.
Lordship.
Even in a second writ petition, you have not challenged the order of cancellation.
No, second writ petition is earlier one.
Earlier one.
8362 is earlier
No,
one.
Lordship.
What no?
After that, I have filed another writ application, Lordship.
Where is that?
What is that number?
Sir, you are not verifying your cause list.
Sorry,
No,
Lordship.
he is handling such an enormous number of the cases.
No, sorry,
He
excuse me,
is
sorry,
getting
Lordship.
jumbled up.
Lordship, kindly pass over, Lordship, next week, Lordship, I can. Next week, Lordship. because there is this confusion, Lordship. With I file another application, that is it. My impression of that is come.
You made her to confuse herself.
No, Lordship, that is the heat application is not come, Lordship. That is frustrating. Sorry, Lordship.
Item 9. Yes. Item number 9.
9, Lordship, is here.
What is the order of rejection?
Lordship, that is that. Lordship, I will come to Annexure 5, Lordship.
Yes, Annexure 5 what field?
Lordship, kindly see 182. 182, Lordship.
Yes. Which serial number? Which serial number?
Lordship, that's page 185, Lordship.
185. Concerning your
Yes, Lordship. My Lordship, kindly come to
serial number 7 or 6? Extreme left.
Lordship.
Serial number 6 or 7?
7, Lordship. That is.
7. And then what is your name?
Lordship, my Mahavir.
Mahavir Infrastructure.
Mahavir.
Where is the Mahavir Infrastructure? I do not find. Serial number 7. Which one is yours, sir?
But Lordship, page 190, Lordship, that is 190. Serial number 19, Lordship, page 190.
Serial number 19.
19, Lordship, page 190.
Disqualified as per clause 2.1.
1.1
In the big four of the eligibility criteria.
criteria.
So what is this 2.1?
Lordship, that is Lordship.
Similar network.
It has to be certified by engineer, Lordship. That is the
Which is the page number where this clause is?
this clause is page Lordship 66, Lordship page. Eligibility criteria, Lordship, page 66.
No, they are referring 2.1, which is bracket 4.
Lordship, 2.1, top Lordship, 2.1
Yes,
eligibility
it
criteria.
is executed similar nature of work,
Lordship.
what 75% of this.
Plus. So, Lordship, in case of contracts funding for more than Lordship, a certificate to this effect must be enclosed from the officer not below the rank of executive. That is the Lordship criteria in the tender construction. The petitioner has uploaded all the documents, Lordship.
Where is that?
Lordship, that is under annexure 3 series, Lordship.
Page.
Page starts from page 159. Agreement, Lordship, enter works. I have.
Page.
Lordship starts from page annexure 3 series.
Well, that you have submitted in format 1.
Lordship,
Where is that? Format 1.
That is the admin mistake by the petitioner, Lordship. Instead of giving a certificate, he has given all the bills, Lordship.
See, there is a format which is prescribed, then how can you do it?
Lordship, that's the Lordship. But all the certificates signed by the executive engineer.
Does it have the state of the Privy Council?
No, that's true, Lordship. Why am I coming?
36 Privy Council.
Lordship.
Yeah.
No, I am on a different aspect. Lordship, can you come to page 40?
No, I am on that aspect. If a particular prescription is made,
Lordship.
you have to comply with that
Lordship,
prescription.
I bow down, Lordship. Lordship, can you come to page 40? My alternative prayer, Lordship, can you come to page 40? There is a relaxation, Lordship. Page 40, in tender condition itself, there is a relaxation. Page 40, Lordship, 40. 8.5.1, Lordship, page 40. Evaluation of bids.
Yes.
Lordship, after opening of the technical bid, the bidder may be asked in writing public online in the registered email ID to clarify on the uploaded documents provided in the.
Provided the uploaded documents is there.
Yes, there are documents.
If there is some changes, then for that they want a clarification. If there is no document which is uploaded, then how this clause
No,
applies?
documents upload, Lordship.
No,
but
sir,
format-
document one is not uploaded.
No, Lordship.
So it is not a document which is uploaded.
But my humble submission for Lordship, I have given all the bills, Lordship. I have given all the bills.
No.
Lordship, they may consider Lordship because it is
No.
very technical bills.
It is a cardinal principle of law that once a
That is, this
Again, your,
last matter, Lordship, and another matter.
what has happened? What actually happened, that writ petition was withdrawn by BBG India Limited?
Lordship, that has been withdrawn, Lordship. I
It was
was
withdrawn.
withdrawn. Lordship,
Your contract was kept in abeyance.
kept in advance for this entry.
And thereafter they issued a letter to BBG.
BP,
How?
Lordship. Now they're going to issue, Lordship, BBG to
No, they have issued, you have said that they have started, they have
Lordship.
and he has resumed services.
No, Lordship, in fact, he is resuming service. They
In the meantime, the CDA permitted BBG to resume service by letter of 25/6.
In fact, Lordship, their understanding is you do the case, we'll allow to work. But my agreement still exists, Lordship. Lordship kindly say annexed to
There's Cuttack Development.
Pata Development Authority.
Who is appearing? You are
Notice has to be issued.
notice. It's a good case. Short notice
Short note.
next week.
My senior can appear, Lordship.
I am appearing in this case.
So can you will accept it? At the time.
I'm in cabinet. My cabinet has not. No cabinet. Yes, number 697. 697 of 2026. The cabinet has not gone. There is no cabinet in the earlier petition. We have served a copy. In the earlier petition for selection tender,
No,
they served a copy.
They withdrawn it or cancelled it. They again issued another what is this? RFP with one additional the conditions by awarding certain marks for presentation. participation was done. The petitioner says that I was adjudged as the
L1.
L1.
There is no
Yet, being
Apprehending
accepted as
that
L1 in order to favor opposite party number 7, some hobnobbing appears to have been done. So that is a very serious allegation which he has made. So who is the tendering authority?
That's the district medical officer.
now I think no cause of action because
No, I am not option number 7. I am asking for
apprehending.
1-6. Whatever.
I'm going to state that now there is no cause of action arises.
Why?
Because now he is anticipating some illegality may come.
No,
Yes, that is also can see the prayer.
You are working since 1-6 just now, recently.
Yes, yes. So person worked or I am working.
So
Already been issued.
Yes.
how can you work it bypassing L1?
That is not.
No, he was not never L1. He was never L1.
That is what he claimed.
Yes, that is claiming that.
So he has shown us that he was
time of filing.
opposite parties number 7 was an L1. No problem. Show us.
Manoj will dismiss with cost merits.
Don't
And
the document.
at the time of filing of the writ application, yes, now I mean, at the time of filing of the writ application, no action was made.
You are representing the
State.
No. The health department as well.
Yes.
You can.
Okay, number one.
You have floated the tender, health department.
OP3 has floated.
CDM.
Manoj, collector has overpowered the CDM.
Whatever. So opposite party number 3, you can represent.
Yes. CDM.
You can represent. That's a part of the government. And who has overshadowed
I
it?
can appeal
The
to-
collector means.
Collector is.
OP2 Manoj.
Yes. The swine is the will be shown a front door.
Yes.
That's
So
all.
that
We left at that.
if there is
If they are not L1, obviously we will impose some costs. Notice.
Malaj, that prayer is also there in prayer number 2, Malaj. At page 19, learned senior is not very good. It is there.
We are OP7.
I am for OP number 7. I am in cabinet. They have
If you are selected in a fair process,
yes.
no problem.
the allegations are actually very serious. Allegations are actually very serious, but tampering everything very serious allegations.
Because actually there is no financial bid. The next day it is selected.
No, whatever. It is.
Item 12.
Great.
It will be listed on minutes.
Next one.
Great.
Your Lordship, it's regarding the refund of the
Yes,
NPM.
he wanted, he withdraws before the last day.
Item number 12. Item number 12, may I pay also some little time given? So take instruction with regard to the release of earnest money. And it has to be
He did not,
refunded.
he did not participate, though he paid, but it
It has
did
to be
not, so he'll have
It has
to
to be
be.
refunded. Only few the Monday will be taken. Monday will be taken, not Monday.
Will you come with the?
Yes, I will take instruction and
No, not instruction, with the refund of the amount.
If it is able to, come with the.
Then we are disposing of directing you to refund the amount within 2
No,
days.
so I don't know whether why they have retained it. So on Monday, I'll call it, sir.
To take instructions from our next resolution.
13.
Your Lordship, again, this is the same matter regarding the refund of the MD amount.
What is your
We've also filed an additional affidavit. before-
Next one. Item 14. Item 15. Item number 15. Disappearing.
But I have received instruction with matter. The work was to be completed within 7 days.
That I have already seen, but he says that he was running a project arrest and all, and think extension on a humanitarian ground.
But my instruction is that the application he sent to the department there. Actually, it was received after the work is signed. Agreement is in some.
Has he produced any medical document in support of that?
Yes, sir.
Huh?
Eight, 21 and 23. 22.
Yeah, geography.
It is on 30th March. This is
Your Lords, have participated in the personal participation, but they have cancelled and bid under annex to cancel. The whole tender was cancelled. Yes, why? Because may see the reason because if I appear, there are only 2-3 grounds on which the court can interfere with the order of cancellation. There is no reason to cancel. Let me see the reasons. Just for annexure 11, you may be seen for a moment. After 4 years, after the PIL is filed in this honorable court, they just cancel. And my B boxes are there. What I've given samples to them are still lying with them. I have taken return the samples. Plus, I have also paid to my vendors for with regard to for and since 4 years participated in the tender. This tender has not been finalized. Nothing has been. The tender has not been finalized because what happened because of this. So how can you in anticipation will proceed? Let us see annexure 10 for a moment. They will give a clarity why they cancel. Why they cancel, Lords? Let me see. Lords, I will explain, Lords, what has happened. A PIL was filed for beekeeping processes to be taken up. Once that order reached to them, they cancelled the tender. Let me see. Annexure, page 141 makes
infra judgment. That full bench decision of this honorable court.
Because M3 is above it. Because M3 is different judgment.
The judgment, if your lordship may kindly see. Last para of that judgment. This honorable court has also
Actually, just
he is claiming both natural justice, so also cancellation reasons for cancellation.
Yes. So Mitri comes in, Milords. The order says it is cancelled. Nothing. 4 years after I have been declared as financially L1, they cancel it. No reasons given.
Roman two. Roman two. Last paragraph, Roman two.
Roman 2.
Huh?
Before cancellation of the tender, there is no requirement of giving opportunity of hearing or prior notice to the highest or lowest bidder. As such, the bidder does not acquire any vested right. And the last paragraph also, the last conclusion. And there is another recent judgment referring to that Jagdish Mandal of the Supreme Court that I could not take out the
We
copy.
have also,
Mitri, Milords, that does.
we have also,
Victim section.
and we have
Yes,
said that
Like the cancellation has been held.
followed it from
we are bound by a special measures.
in Mahadi case.
We are bound by it.
This cancellation was also upheld. Milords, I'll explain. Milords, may I just explain, Milords? Milords, here another judgment is there. If my learned is denying on that judgment, another judgment is there where cancellation of such type was held illegal. The Supreme Court has dismissed the SLP on merits.
Yeah.
That is Rahul Mishra of the state of Orissa. That has already been upheld by the Supreme Court.
Even bound by example.
Milords, that Supreme Court bench is also dismissed on merits.
Supreme Court Sudhir Kumar Singh has.
Now, why it is cancellation? Milords, you see, I'll just bring in my threshold within Mitri, Milords. Just, I'll take hardly Milords 10 seconds more. Milords may see Anisha 10 for a moment. I'll not say, beyond that, we will not say that I don't have a case, I will not pursue it also. Anisha 10 Milords.
Yes.
In the PIL, they say both the tenders are cancelled. By that date, no cancellation order has been passed.
Okay.
Then I come in say, no, it has not been cancelled. They admit that, and I am arraigned as a party in the PIL. On 16th, on 28th, they cancel. That is the problem, Milords. So the PIL petitioner decides my fate.
Cancellation has got. Yes, please. Yes,
Time permission. In that item 14, we have appeared. That appearance may be noted because we have appeared for the corporation, they have withdrawn today. That one I am saying.
Yes. Yes.
Item 17.
Last occasion, Lordship had directed the additional government advocate. So take instruction to this man.
Yes.
Okay. Order dated 20.
Why you are.
Your Lords, my admitted views, my Lord, in the final bill reflected by them has not been faced.
I will see the instruction. In the meantime, my lord, the collector has issued the release order and has further directed the bank. The lordship will find it at the.
We have already taken steps for disbursement.
Because the fund has to be
blocking of your portal and all, everything is required.
Fund has to be disbursed to the executive engineer, then subsequently to the petitioner. So
your Lordship may call it after 3 weeks, then
3 weeks. Let it come after 3 weeks. In the meantime, I think
It is submitted by Mr. last.
your Lordship.
Yes.
20.
is the second.
Item 21. Twenty-one.
50,000 rupees, tell your client to pay.
सीधा देगा आपको लीजिए रसीद
Then what is the purpose of imposing the cost?
Let him.
they have never released.
Oh.
Let's see. Let's see.
What's this?
Audio number. What?
Convincement order.
Never do it for users. No.
Go to the petitioner, the message must go to the petitioner. It is not that you are responsible, it is the petitioner who has to pay. Let him pay.
देगा आपको रसीद
Transfer matter, the PIL, what is this? There should be some kind of a check and balances.
some amount let's see some amount
Certainly, we should have some.
let's see some amount
Legally not filed this petition.
let's see.
Is it doing? What is your plan? Doing?
Doctor, in the medical or admit academics.
Academics.
Academician. What he does, very sir. He's a professor somewhere.
I think so. I was still saying so.
What?
Private university.
No.
Working as the assistant.
What interests you for transfer of OAS officer? No, that. I don't.
Subject. No. Whatever you say.
No, that's
I
why-
say.
No, I even some.
Some amount, yes, some amount. Let's see, some amount will be.
We must be drawing a salary of more than 1 lakh. Doctor, associate professor. Salary structure is much more.
And that will be private.
Private university, you must be having private practice also. Yes.
No, it's a professor.
Unfortunately.
Professor and professor. Yes. Academician. Tuition.
No, sir. Or Mr. Tuition nahi.
Here, two IA applications were filed by petition. It's very simple. But those were dismissed for non-prosecution. After third IA.
Oh, for,
Oh, that's an attempt. He was unstoppable.
in the very same case.
Very simple. That order. Come to seasonal, see that it was not listed since long.
Now it is listed, let him consider the consequences. Brother has said no. That's no.
Item 22.
Let's see some.
Yeah, these are the seeking waiver of the cost imposed by disposing of the. So after particular.
And the opposite party has also given a reply to it.
Amendment application have you received?
I am I find a counter motion.
Yes.
Sir, he has filed an application for amendment of the expedition. Have you got received the copy?
Yeah, I have received the copy. I have also filed objection to that.
Objection to.
Please.
What is the amendment you want to bring?
The letter of cancellation was not incorporated, which has been which was to be incorporated in petition.
Let him, he is challenging the order of termination.
Yes, Matthew.
So that was not there. So in that event, what is the difficulty in raising an objection?
Objection might be.
Maybe on merit you will raise,
Yes,
but so far as amendment,
So, my submission is, it's a case of 2012. The termination order is of 2012. And
2012.
2012.
so
Writ petition was filed in 2012. After
2012,
yes, sir.
yes.
So
After 13 years, he has filed this amendment petition. That fact with regard to that order, it was known to him, and in the result of it, he has referred to that order. His result was filed in 2018, and this amendment was filed in 2025. There is no explanation, my lordship, and his amendment petition. Not a word has been said about why he has not filed this information. There must be some reason for it. My name is 13 years. I don't. My submission was that at flag 11 minutes. Two paragraphs, paragraph 5 and paragraph 6, two paragraphs. Sorry, paragraph 5 and 8.
Your counter you have stated that.
He has taken his region referee, referring to that letter. At paragraph 7 of the region, he has stated.
Did he annex that copy of the?
Yes, we have annexed.
No. Did he annex the copy
Yes,
of the
with the amendment
rejoinder?
No, not in the agenda. He has not filed in the agenda. Thereafter, one appeal he has also not annexed that.
Rejoinder was filed when?
In 2018 months. It was filed on 27/11/2018. That is in paragraph 8.
What you were doing? Why you did not bring it in 2018 itself?
Ashok.
I was unaware of this actually. You were unaware, you were aware in 2018, you ought to have immediately taken out a application.
In 2012, that was communicated to you through registered post. That is the government.
My lord, the bank guarantee was encashed first. After that, the order of cancellation was passed. Before cancelling the contract, they have forfeited the bank guarantee.
Mr. Ashok, you are not explaining. You are aware in 2018 also. At the latest. In 2018, when you filed the rejoinder and received the counter also, you are aware of that fact.
I was not aware of the fact, my lord. My lord, even after all these things, sir.
In your counter, Mr. Naresh, in your counter?
Counter I have
Counter you have indicated?
No.
You are not indicated?
No.
My lord, since I am a
when the repetition was filed, there is no order for cancellation. But in the prayer, yes, I don't know how he got it. He has stated that, but he has not referred to that because that on that day, that order was not in existence. It was filed in April 2012. The cancellation order came in 19th July 2012.
So if you have not disclosed in your counter, then The counter was filed subsequent there too.
Subsequently, but it was not in the report that.
What?
No, you should have.
That's on our, but I don't.
You should have bring it to the notice of this court.
Till then, man, it is the petitioner to should bring particular title. Means very less. I don't deny that. The general file, there are subsequent affidavits of filed.
Both sides.
It is not meeting. Thereafter, he has filed affidavits. Till then, he has not.
But you were conscious at the time of filing the counter
Yes,
with regard to this fact, but you should have brought.
We have, so in a paragraph 8, we have stated only, but that date has not been indicated. Paragraph 8 of the counter, we have stated why you have to cancel.
Where you have stated in your counter?
From paragraph 8.
No, in objection you have stated. In objection you are stated.
I am saying in the counter affidavit.
Counter affidavits and which paragraph?
Paragraph 8 of the counter. You have not stated the order, but you have stated the reasons for it. Why it has been calculated.
Oh, that was there. It's justified.
Justified.
And rejoinder, they have said it has not been. It has not been.
Paragraph.
No, I was looking at paragraph.
Regional monthly kind paragraph. Paragraph 7. Last four violation that year, case 19.
But they have made out a case in the rejoinder, but that rejoinder was filed after the disclosure of the order of cancellation. So it is only the relief which you wanted to claim. The necessary amendments are already there.
In the restriction.
In the rejoinder.
But the main prayer is to challenge that he has not done. It's not the subsidiary or anything ancillary to that you have done. There is a main prayer. Even his amendment petition, there is no word, single word about why he has not filed. He has also filed that amendment petition and kindly talk to their schedule of amendment.
Oh, this is also.
That is page 2.
He has admitted 109. After 4 calls of the tender was awarded to on the Jalara for 812 days at the rate double than the rate which was awarded.
Cancellation was did not challenge.
So he was aware that it has been close. Then the contract of has not yet closed. Very young.
Very.
claim is the payment of money
Yes.
for the bill. He has
And it was, the contract was cancelled.
maybe, but the work which he has already done prior there,
There is a clause in
that you will
Terms of
eat up
condition.
the amount which for the work which he has done.
we can withhold because he has
Withholding is one, and eating up or denying the payment is another.
there is a clause.
What?
He has abandoned the workmanship.
Under the work, on that you have already encashed the bank guarantee. But what about the work, the transport work which he has already done? For that, is he not?
Can be withheld. There is a clause in the agreement.
What clause? That no payment would be done for the work which he had already done?
Because he has put NCL into loss.
What? Where is the quantification of the loss which you have suffered? Where is the decision that you have quantified?
He has claimed, but he has not filed anything. What is his claim? Actually?
He has paid for 33 lakhs. He must have submitted the bill.
Bill he has not submitted.
What are you talking about? He has not submitted the bill for 33 lakhs.
He has not stated what is his, how he is entitled to that amount.
He has not stated in the petition. 20 pages is invested for drafting the writ petition, and he has not stated.
In his representation, he has not.
We have referred to some projects.
In his representations, which he has enclosed, he has never stated that that amount has been incurred by him towards work executed.
He has said that he has executed a work worth rupees 70 lakhs and odd.
Yes.
And then he has claimed that certain amounts have been paid, keeping 33 lakhs.
My concern is that amount what has been done, that can be withheld. There is some project in the winner terms and conditions and special terms of conditions. He has not also indicated this. That is incorporated.
Mr. Ashok.
Yes, sir. Yes, madam.
You have to come to the court physically.
Virtual also, when he can, when he is ready to argue main matter.
Yes, yes. Okay, madam.
When you are ready to argue the main matter, you have filed a written notes.
Yes, madam. I just want to put one thing, madam, that they have issued a revised approval order, which has been filed by me and annexure 20.
Mr. Ashok.
Yes, madam.
When can you be ready with entire brief to argue?
Yes,
main matter.
Yes. Yes, madam.
When?
I can do it at Patag also at the High Court.
Huh?
I can do it at the High Court, High Court also.
I could not understand. What is
any date we will fix that.
Sir, my lord, I just want to say one thing, that the previous Chief Justice Court actually, understanding that I am a non-professional, they have advised me to submit a written argument, which has been submitted by me. They said that it is a request from the court to submit a written argument.
Yes.
I have submitted a written argument
Okay.
pleading the entire matter.
Okay.
I kindly request the court, my lord, to take note of this and dispose of the
Okay, so we take it, whatever the written arguments you have filed is your submission before us.
Yes, my lord.
That's all. We'll take it to consideration.
Okay.
We'll take it to consideration.
Okay.
This is put together.
Yes. Next one, does to keep it for release.
ଆପଣ କଣ କହିବେ ମିଷ୍ଟର କାଉଣ୍ଟର ଜାହାଜ
After that, whatever you have in the pleadings, you have to supplement.
Yes. Yes.
Item number 23.
Lordship, let's see the last order. When you see the last order, my lords, in fact, the hearing was, after hearing us at length, your lordships were pleased to pass this order, wherein instructions were, he was to take instructions and inform your lordship.
Asking for a Passover. On whose behalf?
I'm appearing on behalf of Susan Kumar. Clearly, after another court.
Passover.
Or your lordship can keep it tomorrow because
the next Wednesday.
I'll wait, let him come. Because
Item 24.
The amendment application is also here. Amendment application is also here.
Yes, Lord, the amendment application.
So that has to be heard first.
That is during pendency of the writ petition. While your lordship were in session of the.
No, other side is there, so amendment has to be heard first.
Your lordship had taken note of that, and your lordship, after hearing, had asked the opposite party's counsel to take instructions whether the tender could be awarded. This was after hearing both the parties.
Come, let him come. So it's a small thing that the.
Item 24.
File an IML.
For what? For modification of an order.
You have to order, there is a rural works of a department. That will be only works department. That is the only requirement. I have nothing more.
So it's a correction, yes, not a modification. What are you talking about? Is the correction of a typographical error?
Yes.
Modification.
Just rural.
Where it is used as rural? Huh? Which paragraph?
Para 18%. We direct the office of the rural. That rural has to be eliminated. That is the all what I want.
It is not a rural.
No.
That's a mistake. Huh? This is an application. 15.5.
Requisites filed late.
Belated. Okay. The requisites put in belatedly be accepted. Of
26.
On the last article, notice was issued on opposition party number 2.
requisites again filed late. Same order.
Item 27.
Seven Millers. Millers, I had participated in tender. My bid, I had not extended the bid validity, and because of which, first one, after my denial of extension, they have revoked my bid security. They have encashed it and taken it. I'm just like, so the relevant portions of the.
So what wrong they have committed? Denial, when you deny that?
There is a clause in the contract which gives me right to deny the permission. I will not extend and I can communicate that. If I communicate, my bid security will be returned and my tender will be said that it is akin to, I have been recused from the tendering process. I'm just going to see clause 29, page 57 for
page
57.
Yes.
Last clause, with validity. The validity period of the tender shall be 120 days from the date of bid submission. In exceptional circumstance, prior to expiry of the original time limit, the employer may request the bidders to extend the period of validity for specified additional period. The employer's request and bidders' responses shall be made in writing. A bidder may refuse the request without forfeiting his bid security. A bidder agreeing to the request will not be required or permitted to modify his bid. The tenders are not during the sale period or within the extended period by mutual consent revoke or cancel his tender or alter the tender or any terms conditions thereof without consent in writing of the company. In case the tender violates to abide by this, the company will be entitled to take action as per clause number 30.
So what is this?
Now,
what does it mean?
It means that if during the continuity of the tender, they seek my extension. I deny that. No, I don't want to extend.
No, the validity period of the tenders.
Yes,
shall be 120 days from the end date of the bid submission.
Yes, sir.
So what is this?
So my validity period expired. There were multiple extensions on their request. I acceded to those requests.
No, they could not finalize the
yes,
tender.
They could not.
Within 120 days.
Documents. Also, they could not within 120 days. They sought extension.
They goes on extending this.
Yes, they sought my extension. I gave them extensions.
No, extending the what?
Extending the bid validity period during which the bid is being evaluated.
So they could not start the process of evaluation.
They could not finalize the process.
Okay.
Now, Millers, may please come to Millers.
Then in exceptional circumstances.
Yes. Prior to expiry of the original time limit.
That is 120 days.
So, and the employer may request the bidders to extend the period of validity for a specified additional period.
Correct.
Now, the employer's request and bidder's response shall be made in writing. Now here it begins. The bidder may refuse the request without forfeiting his bid security. So once I refuse, my bid security is protected and I'll be out of the tendering process. Now, Millers. Now please come to Millers. I'll just show the what happened in this entire tender process. Millers, please come to Anisha 4. Page 62.
Page
62, Millers. Because MCL has a special reverse bidding process. In the reverse bidding process, the bidders are asked that whether they want to participate in reverse bidding. One has to match the other. And there is a substantial, by that, the bidders, all bidders who have participated, they go on reducing their bids by substantial portions.
No, I understand.
Yes. Now, Millers, initially, though this was, Millers may say Anisha 4.
No, I'm looking at it.
Yes.
Process.
I was the third by L1. After reverse bidding, I was L1 by then. But after reverse bidding, I became L3.
Where is that?
Because that, Lords will find.
62.
Page 67, your lordship.
Where 67?
62 is L1.
L1, I'm L1. Now reverse bidding takes place. Page 67, last parameters, last table Lords will find.
Oh, you become L3.
Yes, I could not drop any further reduced bid. L1 and L2, they go substantially lower from there. They drop.
So what happened?
After that, Lord may see page 70 Lords. 70 is the first extension this shop. Page 74 Lords is the first extension. I say yes, I agree. This is after 120.
No, I could not understand.
Yes.
Why you are harping on this?
Because extensions, they show
whatever the extension is there,
yes,
whether there or not, you were allowed to participate in a bidding process.
Yes.
There was a reverse bidding.
Yes.
In the reverse bidding, you now become an L3.
Yes.
That means the contract is awarded to L1.
Yes, L1 has been, what they did, in the interim, they did not decide who becomes the L1 because in the meanwhile,
but what is this 67? What is this 67? The document?
Technical documents are evaluated again. The technical documents that we have submitted, they were being evaluated. So what they do, this reverse bidding, they first open the financial upon submission of documents.
No, reverse bidding is always on a financial basis.
Yes. Now the
cannot be done on a technical basis.
After the financial documents are open, they go on evaluating my technical documents.
Why? Why reverse?
Their procedure.
In the
reverse?
In reverse bidding.
So they disqualify L1.
They disqualify L1. L2 says that I did not want to extend my bid validity. His EMD is protected. I say that I do not want to extend my bid validity. My EMD is forfeited.
So this is what this 62 and 67 it is at what date?
62. I'm just bringing those.
What is the date?
21 June 2018 is 67.
June
2018, 21/6/2018, at top of the page, 4:57 p.m. Page 60.
Yes.
So this reverse bidding happens. After that, Millers may see the letter under Annexure 7 series. 5/10/2018. This is the first letter they issue asking me
after the bidding process.
Yes.
They
asked me to extend my bid validity. I go on extending. The Millers may see page 74. 8/10/2018, I agree. I intend to extend. Now, Millers may see this is the last extension I have granted on 8th March 2019. They have sought on 8th March. That's page 77. Millers will find that document.
Yes.
This is the extension. I say I agree that I got to further extend. Now, when the matter stood, the Millers may see Annexure 10 Millers.
So you have accepted till 31st of May 2019.
To extend it till
31st May.
31st May 2019.
Correct.
Now, Millers 4/6/2019, that is on Annexure 10 series. Annexure 10 Millers. Page 87.
Yes.
I say that, Millers may see. Now we are not interested for this tender further and we request you to kindly release our EMD rupees 38,75,000. I intimate that I do not intend to extend.
Their letter was 24. Their letter was 24. No, 24/5.
24/5.
No. What is their letter?
They have not
seeking an extension.
They have not sought. By that time, they have not sought any extension. This letter
after 31st.
They are not sought. After the last extension I have granted, they have never sought an extension.
Okay.
So I say that I do not wish to extend any further. Irrespective of letter being there or not being there. Because 120 days had expired by then. My period of extension had expired by then. Now, Millers, after that, Millers may see Annexure page 88. I issued them a legal notice saying that refund my.
Then you say refund my EMD.
Yes. Now you may see page annexure 11.
Page?
Page 91. 18/6/2019. This is another letter for refund of EMD. Now the impugn letter notes annexure 12. After my period of bid has expired, after I have intimated that I do not wish to.
93 is the impugn letter.
Yes.
This is on 1/7.
Yes, my lords. I had told them on 4/6 that I do not wish to extend any further. They do not address that issue.
Where is clause number 30B?
In E-Millets is at page 52 Millets.
52. When he is supposed to upload the requisite documents?
Yes.
When you are supposed to upload as L1?
As L1. Only after Millets L1, L2 and L1 and L2 were eliminated, then I suppose I.
Oh, I understand. Sir, they are taking shelter under clause 13E.
Yes.
13E talks about something, the requisite documents to be uploaded and to be done in this way.
Yes.
And they are not really banking upon the other clause which you have.
I have
clause number 29.
Yes. They are not going there. They are saying that I have not uploaded. Millets annexure 9. This is the document where they were requiring me to upload documents. And so another document. Also understand the entire affair from that document. Annexure 13, page Millets 156 Millets. Running page 156 of Millets. This document was filed with my rejoinder. This is issued on 7/10/2019.
When they have done it?
Because this is done on 7/10/2019.
Or prior thereto?
No. This is the, let's see the date. Let's signed the space.
No, I understand.
Yes.
This is what is the date of this document?
156 is the entire PCR which I have given. Entire tender committee report I have given. Annexed as annexure 8.
I just wanted, when you have taken or finalized the tender, have you ever communicated to him?
No.
That you have been now become an L1?
No.
You have to come and execute or participate in the evaluation?
No. Lordship may see page 139, running page 139. After the petitioner became the L1 and his documents were scrutinized, 11 documents were found were not in order which he had uploaded. So he, as per 13B, clause 13B, we have to give him.
What is the date?
Date, Lordship, is 5/2/2019, page 141.
And this appears to have been signed in the month of March 2019.
March 2019, recommendation was made to disqualify him and forfeit his tender.
Sir, this is a signature. You are referring a document which does not contain anything but a signature with the date of 23rd of March. And you are saying this document is of February.
Which Lordship is looking at page?
I am looking at page 139. You are referring
139.
Yes.
139. The last page is 141.
Please, from 139, every page at the bottom.
Yes.
Signatures are appearing. You are
290, and all the signatures are at the last page 141. Lordship may see the concluding there.
141.
5/2/2019.
From where I get it? I do not get it. 141 is the continuation.
Numbering blue.
What are you talking about?
141.
The last page would come.
The 139.
Just one minute.
139 starts with the.
No, this is the document which is signature is 23/3/2019.
Then my page marking is wrong, right?
That do not I'll also have answer to that. Page 148.
You need not have to. This is not
I'll consult the page marking, then it will be easier.
What you are referring? I'm just asking.
That is, my internal page of my counter is page 36. And the running page is 139, which is marked in my hand. Internal page counter is 36 of my counter.
Yes. Yes, 5/2, I can get it.
In view of the above, the tender committee after due deliberation decided the following not to accept the following 11 numbers of confirmatory documents.
This is the 5/2.
5/2.
Yes.
Now,
and when you have sought for extension of the validity?
Extension of validity was there till 31/5/2009. That your Lordship will get at.
Up to 31/5. When you sought for extension?
Last extension was sought for. Seven 3/2019.
Correct.
Page 73.
Correct. So you are referring this 5/2/2019. What this document says?
This document says to upload the documents which had uploaded regarding work experience, to re-upload them because they are not matching those documents. One recycle was given to him as per this. He did not upload those documents. Thereafter, if Lordship sees, second recycle for 5 days was given in page 142.
What?
In page 7 days time, thereafter another 5 days time was given to him. Then he uploaded those documents. After uploading the...
Where? 5/2, then it was given that...
Lordship will pay, see, page 144. That is internal page 41 of my counter. Since the revised L1 bidder has failed to re-upload the requisite documents, Lordship, what?
Yes, this is a 26-2.
26.2. In response to revised L1 bidder, Shivam LC failed to re-upload the requisite documents up to 10 a.m. 22/2/2019. Since revised L1 bidder Shivam LC failed to re-upload the requisite documents mentioned in 7 days time given in first recycle, 5 more days time is given to Shivam LC.
So 5 days more will take us, I do not know, was it a leap year or what? 5 days more means it will take to sometimes in the month of March. Correct?
Then Lordship may see page 147 when we re-uploaded the documents.
Internal page?
44. In compliance with the above, L1 bidder Shivam LCG replied to the request and uploaded the scanned copies of the above documents on 2/3/2009.
Yes, he has done on 16/3, that's the recording.
Recording on 16.
And he says within 5 days he has uploaded.
Yes, sir.
Then,
now, after uploading these documents, the committee scrutinized this, and the Lordship may see now, come to page 156, that is internal page 53.
Yes.
These are the tender committee recommendations. May I read notes? To reject the bid of the following bidders. L1 bidder, RKSU, who was originally L1 bidder after reverse bidding. Original after L1 reverse.
So you have forfeited the ND, whatever.
These were the recommendations made to the competent authority that the tender, these bids be rejected and the bid security be forfeited. These recommendations, if your Lordship see, were made on 23/3/2019.
Yes.
The recommendations for rejecting the bid and cancellation forfeiture of bid were made in 23/2008, well within time of the bid validity period. Thereafter, it was put up before the competent authority. Lordship may see the dates given thereafter. But the bid, the approval from the competent authority was after the bid validity. That is admitted.
So when you say that when the tender gets finalized,
after the approval,
if the approval is beyond the validity period, then
yeah, the process had started. That's what
that does not mean your clause does not talk about this.
I am absolutely aware of it.
So if it is not finalized, then in that event he may withdraw.
After 31/5 he has not extended, and admittedly after 31/5 the approval has been given for.
Then in that event it is not finalized. Finalization will only after the approval.
I just wanted to show Lordship that the process has started. Why?
Process will not do. Then what your clause says?
Clause after bid validity.
Then finalization, you could not finalize the tender.
The tender committee had recommended for cancellation of it and recommended for cancellation. Forfeiture of the year.
You cannot stop it.
For manner, it is going to be rejected. Otherwise, all through from 2019 to the
will you believe that a person will upload a document knowing fully well that these documents would be rejected?
No, not that.
How then it can be about?
Not I'm
extended the time. He says, I am not going to.
And time you have been asking him to.
And he has been there. And the recommendations were made within the time of bid validity.
That is not nothing. Finalization has not been done.
These are on the documents. I can tell on that.
No, that's true.
Based on the documents.
Yes.
Our High Court has also already considered this issue. Have 15 minutes. 15 minutes. It is 6 minutes. It is 5 seconds.
How it applies in your case?
Next here, there is also.
There is only, they says that there was already the clause which says under what circumstances they can forfeit the earnest money. And then says that it does not come within the purview of any of those conditions.
Yes.
Very plain and simple case. What is the new law which is laid down?
Not.
This, where is the clause? Give me the page number.
Most clauses that page 57 minutes, clause 29. One thing, the money is deposited before the Honorable High Court Registry. My EMD, because of their failure to file response counter in this present matter, direction was passed to deposit the money in the registry of this Honorable Court.
We have deposited before this honorable.
There is no law which is laid down there.
The tender work for the purpose of construction.
Yes, Mr. Coal
Corridor Road, concrete and bituminous surfacing.
Inside MCL compound.
Come immediately after my release. Read the rest of them. Please, take the things. Please.
Item 28.
Yes, we take it on next week. What this matter? We will take it on next week. This 28.
28.
Oh, yes. What's my learned senior? I requested that it will be. Next.
Item 29.
Read it.
29.
Okay. Item number 29. I'm for the petitioners. So there are three sub-items in the incident case. First is against Binfar Bulna, then it is against SCP Patel, and third is against CDM of HON'BLE. With three petitions, the present petitioner has sought the directions on sought for work order from the three institutions so that it could provide attendance for destitute patients.
Why it is taken up by a single bench and then why it is coming before the vigilance?
What should the assignment has changed?
Assignment?
Issuance of work order category is taken up by the single bench. Then
why it is coming? We have also. Why it is coming?
The second round of litigation.
Huh?
Second round of litigation. We have not challenged the single court.
No. We have not noticed. Not noticed. Why is it coming? We have. Says that it is to be heard by a user bench?
No.
Then how it is listed?
No, it's not.
Because we never opened the brief because the request was made. The same thing was there, so we simply pass it over. You did not point it out. You are appearing that why this matter is appearing before the division bench.
So it was previously this was listed before the bench of learned.
Yes, single bench, and the single bench was taking up the matter in session of this, passing several orders, directing the affidavits to be exchanged. Then why suddenly it appears?
Suddenly came to this court.
At the time of
But the senior counsel requested my senior.
Yeah, but if after the open but now it's my learned senior is out of place and you know. I pray for a short adjournment.
All I request is to.
Okay.
Next week, next Wednesday also.
That is what is.
31.
Go to the party.
Yes, Lord.
That was what. Item 31.
My person this is the tender matter where he has given his vehicles four entries. And similar entries have been accepted, but his has been rejected on fencing. I'll just quickly recap the whole issue. Let me kindly see. Petitioner's technical bid has been rejected. Now the impugned order of rejection is at annexure 2, page 237. The PDF page 258.
Well,
now, if your lordship would see the rejection, petitioner's name is Vidyush Kumar Dhar. I'm reading from page 237. Technical bid documents verified with the original documents. Applied for 4 blocks, but only mentioned about 6 number of vehicles instead of 8 vehicles in annexure 7B. This is the reasoning. Now, the present rate is only related to Binjharpur block, which is at page 238. Binjharpur, because in this he is L1. So even though on this ground other bids have been rejected, we are only concerned with serial number 3 at page 238. And his bid has been rejected.
Disqualified. Binjharpur. You are a Vidyush
Kumar Dhar.
You have been disqualified
on the ground that
you have mentioned only 6 numbers of vehicles instead of 8.
Minutes.
So Binjharpur also rejected.
Yes. We are only concerned with this rejection because others he is not L1. So in case he is restricted only to Binjharpur. Other blocks also he has been rejected.
That's true.
So now my lord may kindly see his document, which is at page 75. The document which they are saying that this document will not pass muster, that my lord would see at page 75.
Yes.
Now what he has done is, the lordship will see Binjharpur, district Jajpur, applied so he has given his
2 numbers. 7645 and 2145.
My lords. He has mentioned it 6 times. And in under column number 2 and 3, he has mentioned Bori block and Botchana block and given just 2 numbers. So he has not replicated this. And in any case, we are only concerned with Binjharpur. Now, my lord may kindly see what others have done.
No, he has given all the same vehicle number for all these 4.
Yes, that is permissible. What all others have done also, your lordship may kindly see. Page 254.
Yes.
No, if my lord would see page 254. No, 254 is his bid, my lord. I'm sorry, my lord. Similar candidates would be at page 243. I'm sorry, I got the page number. Page 243.
Yes.
Now, my lord may kindly see what others have done. This Pradeep Kumar Kara, he is the successful bidder.
Okay.
He has, my lord may kindly see, given the same pattern. 2 vehicles, same vehicles repeated for all blocks.
Yes.
So only on this ground they have rejected me, whereas other candidates who have been declared N1 have followed the same pattern.
Yeah.
So 2 similar bids, 243 successful bidder. Then my lords receive 245.
Yeah, that's true.
Now, my lord, may kindly see page 245, same pattern. His bid was also not
Same pattern, sir. There is a difference. Not a same pattern. What you are closing. Anyhow, we understood what you were. Not a same pattern. Don't say it.
But so far as in my case, that 2 and 3, I have put it in one.
Yes, that is the different pattern.
Yes.
Not a same pattern.
So then in that case, they could have considered serial number 1. N block, instead of rejecting it for all 4 blocks, they could have restricted it to the first entry. And in terms of bid prices, we have shown.
No, it's not necessary for price.
Bid also in black and white, I would be able to show that I am L1 by a sufficient
No,
mark.
it's not necessary. We just wanted whether that is a ground for rejection.
That's the ground.
That's the only thing.
That's the only thing.
And is there any conditions stipulated in the contender document? How it is to be done? Anything, any consequences, something of that kind?
No such condition, my lords. And one important thing is, if your lordships would see, 2 L1 we have given. 2 people who have been given L1, one more would be at page 247. He has also been declared L1 and given the tender. 247.
So obviously.
So for me, they declare me as technically not qualified, but for others, they go not only accept the technical bid, but also go ahead and award the tender. Page 247, Satyavrata Jaina, he has also been declared L1.
I understand.
So he is a successful bidder. So now in this, so far as this Binjapur is concerned, the documents at page number 253 and 54 would show that his prices are about.
So what? We are not concerned with the prices. We are concerned with the decision of rejection.
Prices I am showing because there are only 2 players. It's only restricted between the petitioner and the opposite party, and both prices I have given. His price is there and my price is there. So it would also be in the interest of the revenue to declare me as the L1.
Any conditions in the tender document?
There is no such. This will not fall short of any condition, and that's the reason why we have accepted for several others.
Yes. Can you show me any conditions?
Yes,
Clause, sir.
Your ultimate time is 3.2. He has applied for 4 units, so he has to mention 8 days.
Just 3.2.
My page 27. Page 27. A bidder can be appointed any number of units in a.
Let me read.
Oh, I'm sorry.
Yes.
Then
you can read in your own way. I have read it.
1.9 also, it says it has to accompany by all documents. That's a condition.
You have not said so, sir. You cannot improve your case. What your authority has not taken.
No.
Your authority simply says that instead of 8 number of vehicles, he has uploaded only 6 numbers.
Exactly.
And then you have proceeded to reject.
Yes.
Now you rejected or solely on that the ground, nothing more than that.
I'm not saying, I'm only saying each unit he has to mention 2 vehicles, and after he is selected, then he has to produce documents.
Correct. So now question is, you have not permitted him to pass the stage of selection. Before selection, you have trusted him.
That is because
you say that though he applied for 4 units,
Yeah.
but he has shown only 3 numbers of vehicle, which has seen that in one block, actually, there is no other blocking because they have to give a declaration in the format which you have furnished. This does not contain, so they wanted to apply for 4 units.
Yes, ma'am.
Correct? Others have applied only for 3 units.
True, ma'am.
Correct? So they utilize the box. What they have done is that they have in the right-hand side box, where the number of the vehicle which they disclose, they ought to have disclosed 4 numbers in that second block. Same number, repeat.
True it is.
Correct? Which they have not done.
Ma'am.
And that makes you to reject his bid in its entirety.
But my humble assumption is that will be no case of segregation as submitted by my learned friend, because once he applies, 3.2 says that he has to mention 2 vehicles for each unit. Maybe, my lord, since you're
Maybe the same vehicles, but this clause says that if he is selected, then for additional vehicle also he has to give the documents. And he has to show that for each unit he has attached 2 separate vehicles. That cannot be done. That is what is this.
But even assuming that as your lordship was pleased to observe that there are no separate blocks for mentioning for the 4th unit, still then he should have mentioned for Bari also 2 and for this Bartana also 2. He has not done that. What he is saying, because I am L1 in Binjapur, I should have been considered for that. My humble assumption of the 3.2 doesn't make such a segregation. If your lordship permits me, only I will read the first 2 lines itself.
In absence of any space. In absence of any space.
But I am not even questioning that it should be in a separate block.
Let him read.
Please read. A bidder can be appointed in any number of units in a district. The bidder selected for more than 1 unit in a district or in other district taken to the shall have 2 separate vehicles for each unit selected.
Correct.
The bidder shall upload the vehicle details in annexes 7A and 7B at the time of bid submission. So this 7B, your lordship will kindly turn to page 75, which my friend was pointing out. 7B, for each unit 2 vehicles. Here, he has total mentioned 6 vehicles in respect of 4 units.
Yes.
So my humble submission is, the question of he being selected and post facto he submitting documents will arise only if he is selected. So he has mentioned only 6 vehicles in respect of 4 units. Because he is L1 in respect of 1 unit, he cannot say, because he has applied for 4 units in total together, and therefore he cannot segregate and say, because 1 unit I am there, I have mentioned 2 vehicles, so I should not select.
Sir, please read. Don't go so fast.
Ma'am.
Can you read this clause with me?
Ma'am.
Slowly.
Ma'am.
Let us understand.
Ma'am.
A bidder can be appointed in any number of units in a district. He can be appointed for any number of units within the district. That's your choice. The bidder selected for more than 1 unit means the selected word has to be understood at the stage when he is adjudged as L1. Not at the time of submission of the bid. It is all after he is being adjudged as L1. Selected for more. That's selected for more than 1 unit. If he found that he selected L1 for 2 units in a district or in any other district taken together, if he is already selected in other district, shall have 2 separate vehicles for each unit selected. That means if he is selected for 2, then he has to show 4 vehicles, that 2 for this unit and 2 for another unit. It is post declaration as L1. Then the bidder shall upload the vehicle details in annexes 7A and B at the time of bid submission. So he has to submit 7A and 7B, that what is the number of the vehicles which he really intend to put or attach to a particular unit if selected. If selected.
This is pre-selection stage.
This is a pre-selection stage, 7A7.
Right.
After that, means after he is selected, the successful bidder, otherwise the word successful will not come.
Absolutely.
That means after selection, shall be given 7 days time in writing to produce documents in support of additional vehicles.
Yes.
And she or she may be asked to submit the updated declaration as per format annexure 7B. So second declaration after being selected. 1 7B at the time of submission of the bid. Second 7B after being selected.
Yes.
He has to give. Correct?
Yes.
As to the name of the units, he or she has been selected for appointment as transport contractor in the district and in the other district of the state before execution of an agreement. On his failure to submit the declaration, then the EMD shall be forfeited. So there are two stages. One declaration at the time of submission of the bid. The second declaration when you communicated to him, now you have been selected for this unit. You give the 7B declaration, which vehicle you want to attach. Have you sought for a second declaration?
My second declaration will only arise in my humble submission. I am only relying upon that the bidder shall upload the vehicle details in Annexure 7A and 7B at the time of bid submission. This, my lord.
There is a condition that he has to submit. Suppose if he applied, he has given, you can discard that your selection. In so far as the body is concerned, I am not accepting. So far as the 4 we will not accept, we accept the 3-1 only. Choice is with you. Out of Bari and Baranchara. Whatever.
Would be
how can you reject the entire tender?
That is because once you apply for 4 units, and if you don't so maybe repetitive,
maybe that he cannot be considered.
Reset the entire thing. That is what I beg to say.
It does not talk about this.
But
it does not talk about.
That is what is our interpretation, and that is how we are considered.
No.
That's much more for me.
The word selected is
it's a more important factor. This is post the
post managed visualize a situation where manager doesn't upload to it and he gets qualified in all 4
He will not be uploaded. What are you talking about? Additional vehicle, then why it comes?
Additional vehicle question will arise if he is
selected for more than 2. That is, that shows what? That you can alter the number of the vehicles, which you have shown in 7B at the time of submission of the bid.
Provided that 7B is in order.
Oh.
Because that is a pre-selection stage. That much.
That clause has to be read as a whole.
That's why he is fast. He hurriedly went. That's why he says slow. Let us go one by one.
I can see. I have understood that.
No, sir.
That much.
Let us hear
one thing that I wanted to one clarification. It's 2 vehicles. Everybody has given 2 vehicles for all. So there's no question of C.
Don't open mouth too wide.
No, I'm just saying.
What the mistake you have committed is a very
appreciate. But everybody has done.
No, they have done in a very correct manner.
But all have given 2 vehicles.
Sir, for each selected, you have given 2 vehicles for 2 districts.
Yes. That because of space or whatever reason we have not mentioned.
If you have mentioned, you could have mentioned this. Why you have written applied in the middle column?
That I appreciate.
Can you not give 4 numbers within that column?
That I bow down.
And he cannot claim a negative equality. That is also there.
Negative equality is not a principle. Applicable here.
But that is not applicable.
You have nothing
but my friend is.
Because here, my lord, the conditions of tender stipulates that if he has not submitted as per the
tender form.
Have you submitted a subsequent 7B declaration?
Yes, I have not selected for other units.
I am asking you for this unit, have you submitted a second?
No, not
7B?
required at all. If I have selected for 2 units, then I have to. He has made allegation against the person, those who are not party here.
Just let me clarify one thing.
He wants to choose, pick and choose only for Binjarpur. Cannot, madam. Because the entire tender process for 4 units, madam.
Is L1 there?
Because how he knows? After opening of the price bid,
He's not
he sit as a consider and thereafter file the
Show me from the clause that this submission of the subsequent 7B is only in respect when a person has been selected for 2 units.
that has not been clearly mentioned. But
how do I?
Your Lordship may see. Your Lordship,
you are saying so boldly. Tell me.
My Lord, your Lordship may see.
Please, language after that.
4.8.
Tell me.
Two aspects. One is selected, another is more than one.
More than one. If he has selected, then
no, please. I understood. Tell me the.
I have not selected more than one unit.
7B is required only when he is selected for 2 units.
No, more than 1 unit. It is more than 1 unit.
That means 2 units or 3, 4. Show me.
Your Lordship may see 4.6. That the repeated clause.
This is I am looking at 3.2.
The repeated clause is there, my Lord.
3.2. Tell me.
3.2, Your Lordship. Bidder can be appointed in any number of units.
Please tell me.
In a district, the bidder selected for more than 1 unit in district or in other district taken together shall have 2 separate vehicles for each unit selected. The bidder shall upload the vehicle details of 7AB in the time of submission, my Lord. After that, this
now read carefully. After that, in submission of the
shall be given 7 days time in writing to produce documents in support of additional vehicles, and he may be asked to submit the updated declaration as per format annexure 7B as to the name of units he has been selected for appointment as transport contractor. After that, I have submitted about those 2 vehicles and I have been given the agreement has been signed, my Lord.
Where it says that if it is more than 2 units.
My Lord, more than 1 university has been stated, my Lord.
No, after I do not know. It does not talk about that. After that sentence.
Apart from that, that has been repeated on 4.6 plus 4.6, page 29, my Lord. That is there, clarified there.
No.
My Lord.
What is the clarification?
The bidder shall furnish a declaration in the prescribed format enclosed at annexure 7A and B, declaring that he will give details of vehicle as per clause number 3.2.
No difficulty.
In case of which are appointment in more than 1 unit at level 2, level 1 transport cutter, she shall submit updated 7B with separate 2 vehicles as per tender condition, my Lord. There that has been so. And apart from that, my Lord, clause 1, my submission, I have been selected in a transparent manner because other 2 persons are there. Because I became the L1, I have been selected in that case. I am continuing since last 9 months, near about 10 months. I am continuing, my Lord.
What is the duration of a contract?
2 years.
2 years till March 2027, my Lord. Your Lordship may see. After notice, page 1 has been out. After notice was issued in the writ, there was no interim order. He was appointed. At page 20, the conditions are stated how the tender will be filled up, my Lord. 1.5 to 1.9. And I have stated in my petition, and the petitioner has choose to challenge only in my case, though he has rejected in each and every unit for the same reason. Apart from that, my Lord,
On the date of filing of the
he has not signed the documents as per the tender condition, my Lord. No.
You can't improve a thing.
I cannot. I have seen from here on.
Just reminding you of MS Gill judgment of the Supreme Court.
I cannot.
You cannot.
It is not my
successful bidder, nor they can.
They cannot involve, my Lord. It is not my case of taste here. Because I have been selected in a transparent manner.
They can take this plea, or you can.
Reasonings on which the order is best to survive or fall.
Correct.
Yes.
There's no question of supplementing here to justify. The only thing possible
here
is
from the documents I could able to see that.
What is the equity has to be done in a correct manner.
that part is
I have already
only
submitted my
we are in June,
stating that
it's up to March only. I think 9 months more. That much you are seeing.
and my submission is he cannot pick and choose. Well, he is rejected for every unit. For 4 units, my Lord. Subsequently, when I discovered that I'm not L1, I'm only expressing the call for one.
My lord,
Not
yes, said he can sit on the only document. He can proceed to have a declaration in his favor that the rejection was improper. But the found is that even if I get a declaration, it will be a mere paper declaration because he is not an L1 in other districts or a unit. So he will not get the contract in his favor. So that will not upset.
It is not the ever.
What he says that this declaration will definitely be beneficial to him in respect of volume.
And it has not been stated in the date also.
What is this? So we can go for it. We can say declare that this is wrong.
Yes, the lordship can declare.
But it will be a mere paper declaration, nothing more than that. Because even if he is allowed to be considered, he will not get the contract because he is not L1.
Here also, this the lordship to see whether we offset at this stage.
The author has misread his own language.
And there has been an interpretation, it is always subject to correction by the Honorable Court.
We have heard otherwise. Author supremacy in the front. We have heard.
Mr. Das always refers to that.
He is sitting in the backside this time. Well, my friend is there in this case.
Yes.
No. Okay.
The lordship agrees because only for the rest of the period we are agreeable. If your lordship agrees with us.
Yes.
32.
2 years.
2 years.
Added. 9 months later.
In the end of March.
Item 32 today will file an affidavit to the regender.
Regent lordship, pleadings ready, everything is ready, lordship. Let us fix at 2 o'clock, lordship.
Yes, we don't have an objection.
Yes, sir.
Without this affidavit, they can.
Yes, I can speak, sir, to me. Earlier, it was fixed, lordship, for entire pleadings are ready. It will take only 10 minutes, lordship. We already had this matter. So, I will not rely their affidavit, lordship. Rather, they have supported my case, lordship, only that I will demonstrate before, lordship. Lordship, can remember this matter, lordship.
Taken on record, let them accept, not to accept, lordship can proceed. We don't have that.
Lordship, kindly remember this matter. A tender, lordship.
This part is listed during the vacation.
Yes, not price.
Yes, for
you get the entry order, paying for.
Because there are threat to lordship for discontinuous by ongoing works. That's why I had filed lordship, this case, lordship. That protection I have given. They have.
But we are conceding that the previous work, what they are doing, we don't have any objection, let them continue.
We had apprehension, that's why that was there, lordship.
Also, they get the entry order in this
There
message.
should be no, there should not be any embargo on the petitioner.
Lordship.
Continuing the
On their statement,
that was
lordship.
already undertaken by him prior to the included application of blacklisting dated 2/12/2025.
Lordship, on their statement. They said lordship will not take any action. That's why lordship.
No. But it says that before blacklisting, what you were awarded a contract, you will continue.
Yes, that was my apprehension, lordship, because they were going to lordship.
Yeah.
That was lordship. But now, lordship, kindly remember this matter. That the tender lordship was floated, last date was 25/11 or 24th. Last date of tender lordship. And immediately, lordship, they cancelled the tender on the ground of lordship, the technical fault. Lordship, but during technical evaluation, lordship, there is no finding that I have filed any documents for or anything, lordship. After cancellation of this tender, after 5 months, lordship, when they have come up with a new tender, now, lordship, they are raising a point that I had given some document which are not genuine. That's why, lordship, they have passed a blacklisting order. And lordship kindly had this matter in detail, lordship, because there is no finding. Lordship kindly see in counter of what they have given, lordship kindly see. That it will only this document will suffice, lordship, and their admission, they are admitting not we have not done it during the evaluation, we have done it after the evaluation.
After cancellation.
After Lordship, grateful Lordship. Grateful Lordship. Lordship, kindly see there are documents they have annexed Lordship. It starts from Lordship their counter. Running page Lordship, it is annexed 2, running page 10 of their counter Lordship. Their counter
is
counter Lordship. Since long they have filed that. Yes. Let's go to this. Counter dated Lordship, that is 15/4/26. Page Lordship, internal page 10. That comes. 10 begins. Begins Lordship. 10 begins Lordship. Then Lordship kindly come to page 11, next page Lordship. Lordship, they have given the entire tender evaluation proceeding there Lordship. Lordship, kindly say that they are saying the last date of tender is Lordship 25/11/24. Let's be given that entire proceedings and then Lordship the 3 names they have given. There are 3 tender committee members are 3 fellows Lordship. You want Jiban Sir, Subodh Kumar Chatterjee.
Not required.
Then Lordship kindly come to they have given in the tender details. Then Lordship kindly come to clause 2.5. Page 13 Lordship, clause 2.5. The technical bid tender is open 25 and 24. Stipulate such and such. Then Lordship kindly come to given the entire tender conditions. Nothing else. Then Lordship stated come to page 17. Nothing is there, Lordship. No finding, nothing. Page 17. The opponent's clause 6.1. Page 17. Lordship, page 17. Lordship, as per railway board letter number such and such, the reference, publication of tender notice in newspapers is mandatory. However, inadvertently, the tender notice has not been published in newspaper for the instant tender, as CPRO office was not informed in writing regarding the same. Hence, tender committee is to opinion that the instant tender be discharged and fresh tender be floated with publication of tender notice in newspapers. According to Lordship, they have Lordship cancelled the tender. So there is no evaluation, nothing Lordship, and Lordship, the condition says if during evaluation it is found to be have filed first document, then penalty provision there. There is no finding, nothing Lordship, rather than own admission after 7 months Lordship. And in account of the admitting this administrative work, it is not coupled with tender conditions, and we have done it in an administrative manner. So Lordship, the tender condition once they are cancelled and the no tender conditions, then none of the conditions is satisfied, and then in affidavit to the admitting, it has been done after 7 months Lordship. Fresh tender and fresh allotment of their Lordship, and they have cancelled since last that is on 20.
AKG construction.
So blacklist.
AKG.
AKG. Lordship, I have given AKG and Patna High Court on judgments. AKG. Lordship, I have given AKG and Lordship Nirman Injicons Lordship, that is Patna High Court judgment Lordship. And also Lordship Honda Infra or their super blacklist there. Here Lordship, the ingredients is not their function of Lordship when they have cancelled the tender and there is no fighting and there is no technical evaluation. Can the Lordship, that clause Lordship I had pointed Lordship in tender conditions, only one clause available, page 21. If Lordship certificates submitted by us are found to be false, so there must be finding. There is no finding during tender. There is no tender evaluation also. Their state have cancelled because of Lordship. They have not floated proper tender as per the circular, their own circular. They have cancelled on the threshold Lordship. And the entire evaluation they have annexed in their counter Lordship, and that is their entire contention.
After cancellation, they have no authority to
Lordship
verify
Lordship. After 7 months Lordship. After 7 months.
Never evaluate.
Lordship.
During the process of
Lordship.
tender.
My lord, this is a case. In first tender, you have submitted some documents. is found to be false. That is annexure 1 FR counter, page 6. And that in document, it is to be informed that this letter was communicated by the general manager.
DSG, there is only one question.
Yes.
Question is, when a particular tender process is set at rest, which receives unnatural death. May I go with this expression?
Yes.
Once you cancelled it, that means it receives a natural death. Is there any administrative the provision in the administrative law to do a postmortem?
It is not a case of postmortem. It is a case where a person has
That
submitted.
is what is there, because the question would be of two natures. One is that once you decided before a technical evaluation stage that you do not want to proceed with the entire tender process, that means that you have put into a tender process. Whatever was there, it has not reached to a scrutiny level. Then you must have floated the fresh tender, because you have given a valid reason for it, based on the Vishweshwara Rao's judgment of the Supreme Court at that point. You said that it is required to be uploaded or published in the newspaper. Since this tender was never published in the newspaper, it would not be proper for us to continue. Then what will that event, whatever is there, because they should get an opportunity. They should get an opportunity before you proceed to blacklist them. First thing is the false document. If you have reverted to an authority to see the authenticity or the genuinity, then you should prize it. Now we have got this. What is your answer to this? You have not given anything. Perceiving everything to be wrong.
We have tried.
No.
Yes.
Where is
the
proceeding?
First, we see the so-called notice.
Have you confronted him with this document?
Yes.
Where is that so-called?
Let's may come to the page 9 of our counter.
Yes. I just wanted to look at the document. Sure.
Yes, this page 9. Let's may see the letter dated 29/11/2024.
Yes.
That letter subject is, it was written to the concerned authority that yes. Sir. Page 32, na? Sorry, page 32 of the writ petition.
Yes.
Page 32 of the writ petition.
Yes, show me.
That letter shows that it was written to the Lakman Associates, plot number such and such, etc. So cause notice against the memorandum and statement of charges and misconduct served by the railway board. Letter number such and such, dated Lakman Associates, dated 12/8/2025, enclosed. Railway board, by letter under reference, has served a memorandum and statement of the charges misconduct enclosed duly signed by the executive director, Civil Engineering G, and favor of the Lakman Associates in so cause against the action process to be taken against your firm. In view of the above, the reply recommendation should be reached this office to so cause by 19/9/2025 as mentioned in memorandum. You full stop.
Sir,
you may also request to present your
actual one is page 33.
Yes. Yes, that's it. Next page. This is the next letter. This is the reply given by him.
Yes.
In that reply, he has given the paragraph 3, or she may come to this page. I have uploaded the 3 years turnover 2020, 21, 2023, 2024. They are not false. They are with the number only 2021, 23 provisional number. By mistake, it was uploaded by mistake. Is that because the mistake uploaded? When the verification term went to our firm, he has not given any statement in which it indicates that the financial statements are false. Moreover, this is such and such. Then, yes, then we have taken whatever verification taken the BSP, Bila Steel Plant. They have given that whatever verification document they have submitted, uploaded with the system, it is not issued by us. So the bonus lies with them to establish that yes, I have not given the false document. I have not given any sort of falsification to the authority concerned. Let's see the
Yes.
Today we have filed affidavit. That affidavit was made to the page 12. Which document?
What you have done?
Yes, page 12 also. This is the format for the certificate to be submitted, uploaded by the tenderer, along with the tender documents. This both the parts. Then Lordship on the prospective paragraph. I have not checked the time. We understand that if the contents of the affidavit certificate submitted by us are found to be false at any time during the process of evaluation of the tender, it will be lead to be forfeiture of the bid security and may also lead to any other action provided in the contract, including banning of business for a period of up to 2 years. 5 years is cut, 2 years. Further, I will introduce such and such. This document was submitted by the petitioner himself to the authority.
It says. Now I'm going to technical.
Yes, ma'am.
What it says?
It seems that
if I have made any false document during the
process of evaluation.
Have you done the evaluation?
Yes, yes.
Has it reached to the process of evaluation?
Yes.
Because before the technical
then let's see my
stage comes, it is already cancelled.
Yes. Page 34, let's see.
Page
34.
Yes.
That is letter dated 29/11/2024.
Yes. And when the cancellation was done?
Yes.
I'm asking you, when you cancelled the tender?
Yeah. We have cancelled you verification confirmation. Verification.
I am talking about when you cancelled the tender.
That was cancelled on January 2025.
January 25.
Yes. Prior to that, this verification. This verification was letter was 29/11/2024.
Correct.
That is subject is verification confirmation of the work execution by the Lakshman Associates, Bhubaneswar, regarding the work completion certificate issued from the reliance.
You sought for the clarification on the genuineness of the document.
Yes,
that's true. Then what is the reply?
Yes.
What is the reply?
Reply is coming on page 36.
36. What it says?
That was November 2029 to 2000. Reference to November 2000. They have communicated us on December 2nd, Monday, December 2nd, 2024, at 4:45 p.m. That it is to be informed that attached documents and completion certificate have not been issued by the BSP such and such. Furthermore, while examining the attached documents of the mentioned documents such and such, the purchase order is found to be false, and in this regard, it is on 20 December 12, 2024. It was forfeited on 2025, May. We have cancelled this first tender. That we done. Then we floated because of technical issue, we withdrawn and we will second issue for the self-tender. So whatever action or proceeding has been made, not after the third, it has started from 2024 onwards. After that, the first tender was withdrawn and second tender was floated. So whatever documents are submitted, it was examined, it was my correspondence, verification was made prior to our withdrawal. So if a contractor who is working with us in many work, not in one work, ongoing work also going on, he will give the first document, and basing on the circular, he has to restrict for report. That's why we are not touching about the other works he's executing. We are not very bad because we don't have a scope. The
law also you cannot.
Yes, law also you cannot touch. Yes, that is correct. But law also you cannot touch.
Prospective in nature.
Prospective in nature, yes. This our guideline also say, plus you may come to the exam. This guideline I have received, I have not given it. The clause 17. In case any divorce, 18, the contracts concluded before the issue of the debarment order shall not be affected by the debarment orders. This is the circle of the. Now our issue is that the person who has participated in a particular tender we have found to be passed, even though it was withdrawn and if the same tender was floated the second time, he cannot say because in first tender I give him first document. For second tender, this document may be taken to consideration. Because I am not participating.
Yes.
Lordship, kindly see for us my senior statements for us contact their own record. Lordship, I have demonstrated they have annexed by affidavit the entire tender proceeding. The entire tender proceeding available at starting from page 10. Lordship to page is complete page 70. There is no whisper of a single word regarding this Lordship communications or in the proceeding itself. It clear appears Lordship that there is some inquiry. So it is Lordship there in personal capacity. It is Lordship kindly see the cost of representation. Again, I am bringing Lordship kind to start from page 10. The entire tender evaluation is there, Lordship, and they have written every bit by bit, Lordship, every minute's proceeding. Lordship, there is no finding. Lordship, kindly say, please come to the one clause. What my learned? There is because they resorted to the particular clause. They have Lordship gone for this banning, and there is a available of clause, Lordship. Lordship, that is that running page, Lordship, kindly see. Running page 21, Lordship. There is a tender condition itself. We, on page 21, Lordship, understand that if the contents of the certificate submitted by us are found to be first, so at the end time during process of evaluation, so these two ingredients are very Lordship, requirement law in their Lordship. There must be evaluation and there must be a finding of finding first document. And they will Lordship, what they will do, Lordship, they will forfeit my EMD and Lordship, they will blacklist me for 2 years. But immediately, Lordship, on February 2004, 4th February, they refunded the EMD. Yes, and the prior and they cancelled the tender. And after 8 months, Lordship, they are resorting this action when they have, under which authority, under the administrative laws, Lordship, there is no such power. We don't have employer-employee relation with them. They have resorted some action under the terms of contract. And the terms, the two requirements under law, that is, Lordship, finding and evaluation process, both are absent in this case, Lordship. And by affidavit, given the entire proceeding. What my Lord is showing, Lordship, that is beyond the proceeding, and that is maybe their personal communication. That is never within the tender proceeding. As available under Lordship, their own annexation under annexation to their counter. Lordship.
This is my last submission for that. Whatever document they are relying upon, that is their document which is submitted by them about in the time of submitting the application. Whatever the process they have submitted application, the process starts. Basing on that, you have proceeded all correspondence, everything.
The judgments last time I had given, 4 judgments I had given, Lordship.
AKG and.
AKG and Patna High Court, Lordship.
Justice Bajanatli's judgment.
Lordship, grateful, Lordship, grateful.
My lordship, may I mention item number, yesterday one item, my lordship, it's Upasana Trust versus Union of India, my lordship.
38 to 43. Matters under the heading for wood rails. Item number 38.
There were item 30, my name may be deleted, it has been transferred.
Not called.
It has been transferred from you. No, item 33.
This is not called.
Next item only because I am sitting for that. My name may be deleted.
State is also filing a counter.
I am appealing for that.
It is, yeah. Also, you cancel that.
33, you are.
I am appealing in that case for the petition.
His name.
And exam also filed a counter.
I have no wakalatnama, but name.
Wakalatnama.
23 6 months.
But exam also filed a counter serving the copy on the news.
My lordship, may I mention one case, my lordship, it's Upasana Trust.
No, he is my assistant.
For orders wood rail. Item number 38. Display 38. Item 38.
Over his come.
38.
Lordship, on behalf of Suvankar Raut, I may
Withdrawal of the writ petition is given.
Yes.
There.
Yes, ma'am. Both the cases.
Yes, all the cases. Think over that.
Item number 40. Item number 40.
39.
That means already. Item 40.
I am appearing
Withdrawal of the same.
Both the cases.
41.
Item 41. Item number 41. Yes, ma'am. Red flag A, ma'am. Item 42 already order passed. Item 43.
43 also withdrawable.
All the matters, ma'am. All 4 matters.
Pardon, Article 7, I dated contemplative paging and completed the common Monday, man.
We have started taking up the hearing matters. Now, every day there are 3/4 matters where we have to dictate. So give us some breathing time. Let us also have some time to do it. I understand.
23 was passed over. He is here, madam. So,
have you seen that 4 matters have been kept? We are just writing and then started giving a dictation.
tomorrow
I should consume another 3 hours.
would you actually consider taking it up tomorrow?
Already this matter only delay to be condoled. Let it come on Monday for consideration because on 6 and contempt is fixed matter. So that I can get
common 1st July.
No, do one thing, that application for condonations, keep a heading of an applications only, and then we can dispose of those condonations. Not the main matters, only the applications ready and do the application.
But I was requesting for that.
My lordship, may I mention one item, my lordship?
Interim prayer, that is a judicial order. It's considered by interim prayer. Can it be tomorrow or sometime next?
My lordship, may I mention one item yesterday?